Go back where I.
Good morning again, commissioners. For the record, this is Assistant Attorney General Christian Aguilar. I represent the State Board of Land Commissioners. Today is Tuesday, March 12th, 2026 at 8:30 a.m. This morning, we've been in executive session to discuss two matters. One, a pending court action, Denver District Court case number 2025 CB 33341. And the conveyance of an interest in real property in Lake County in connection with Ecosystem Services lease number ES 118010. These matters were noticed on the agenda for executive session and were authorized under for the first matter, section 246402 3A2 and 3A3 of the Colorado Revised Statutes. And for the second notice matter under section 246402 3A1 of the Colorado Revised Statutes. No board actions were taken in executive session, and the board is now back to its open session and ready to proceed with the agenda.
Chris. And welcome everybody joining us now to the March meeting. We have a full complement of commissioners here and want to welcome you to the session. I also want to acknowledge and thank those who took the time to submit public comments, which have been shared with all the commissioners and reviewed. So we appreciate your effort in that regard. And so then why don't we pass it over to Director Rose Marino for any announcements?
Chair, I don't have any announcements today.
Okay, thank you. If anyone listening online or in the room has any comments about topics that are not on the agenda for today, we have a few moments where we could hear those. Please raise your hand either here or online.
Appears we have no hands raised.
All righty then, we'll proceed with the next agenda item, hearing from Aaron Ray from the Department of Natural Resources.
Morning, Commissioners. For the record, my name is Aaron Ray. I serve as Director of Policy in the Executive Director's Office, the Department of Natural Resources. And it's a pleasure to be with you again to share an update on behalf of Executive Director Dan Gibbs. First, a note on DNR staffing. I'm pleased to share that Richard Fields, our Human Resources Director, has been chosen as our next Chief Operating Officer. Richard will be filling the role that Wendy Padilla held prior to being appointed as DNR's Deputy Director. And I've worked closely with Richard in my time in the department, and I am delighted that he's going to continue in this leadership role in the Executive Director's Office. It is the season for confirmations, and we've recently scheduled the confirmation hearing for Chair Frobe in the Senate Ag and Natural Resources Committee on March 19th. And the department is excited to have Chair Frobe continue her service to the Land Board. On the budget, State Land Board's FY 26-27 decision items, including requests to enhance energy lease compliance and oversight and tribal consultation engagement, were both approved by the Joint Budget Committee in the figure setting hearing. And the next step in that process is for the introduction of the long bill in the House, which we are anxiously awaiting. Staying on the legislative front, one of our priority bills, the Outdoor Opportunities Act, which is House Bill 1008, passed the House with bipartisan support on March 9th, and that bill is on its way to the Senate. We've gotten many stakeholders in a good place in the bill, including agricultural stakeholders, sports persons, conservation organizations, and water providers. And we're continuing to work with counties to resolve some of their outstanding concerns. DNR's other priority bill, our underground injection well legislation, has also been moving through the legislature with bipartisan support. That bill has passed the House Energy and Environment Committee and the House Finance Committee, and will be heard next in House Appropriations. Moving to federal updates, Congress is beginning to draft federal appropriation bills for the federal fiscal year 2027. Most House and Senate offices are accepting funding requests for projects that meet congressionally directed spending or community project funding guidelines. For folks who are interested, you can find additional information about that on congressional members' websites. We have entered into a memorandum of understanding with the BLM, outlining how we work together through shared stewardship to manage Colorado's natural resources. DNR has a very similar shared stewardship MOU with the U.S. Department of Agriculture and the U.S. Forest Service that we signed in 2019. And the goal of these MOUs is to have state and federal agencies work more closely together, managing public land in Colorado. And so we're excited to have that formal relationship with the BLM. Moving to water, as we talked with you about in the past, Colorado has been in discussions with other Colorado River Basin states for multiple years, seeking consensus around future management of Lakes Powell and Mead. As part of the Bureau of Reclamation's ongoing NEPA process, there was a federal deadline of February 14th to incorporate a 7-state consensus into the Bureau's environmental impact statement. That deadline did not yield a consensus, as you likely know from the media, but DNR continues to engage in discussions with the other basin states and with the Bureau of Reclamation. And most recently, we submitted comments to the Bureau of Reclamation on their draft environmental impact statement. Colorado's comments outline our concerns with that environmental impact statement, including inappropriate federal actions that are outside the Secretary of the Interior's authorities, failure to impose adequate shortages for the lower basin, and the reliance on assumptions around water that we don't believe are accurate. We will continue to engage in any negotiations and in the DEIS process. As you know, in many parts of the states, we are seeing snowpack far below average, including record lows in many parts of the state. On a statewide average, we're just over 63% of average snowpack as of early March. That's the second lowest snow water equivalent volume in the past 46 years. And the U.S. Drought Monitor has 38 counties in Colorado experiencing severe drought. As you all know, that will affect water users of all kinds, and we expect that water usage will be curtailed in many parts of the state much earlier than in normal years. It's likely that in the next few days, the governor will activate the Colorado Drought Task Force, which can advise on actions the state can take to reduce the impacts of drought. Moving to Parks and Wildlife, as folks are likely aware, there was significant attention on last week's CPW Commission meeting. The commission heard a citizen petition which sought to ban the commercial sale of fur in the state, along with updates to fur bearer regulations. The commission voted 6-4 to advance the petition to ban sale of fur and directed CPW staff to begin the rulemaking process to implement that petition. CPW staff also presented on a series of proposed regulatory changes to manage fur bearers, and those regulatory changes were a product of a working group that consisted of a wide variety of stakeholders. The proposed changes in fur bearer harvest are expected to be finalized at the May CPW Commission meeting in Grand Junction. On the energy front, yesterday, the Senate Transportation and Energy Committee held confirmation hearings for 3 key DNR appointments: Brett Ackerman and Mike Cross for the Energy and Carbon Management Commission, and Christopher Simmons for the Orphan Wells Mitigation Enterprise Board. And I'm pleased to report the committee voted unanimously to favorably recommend all 3 for confirmation by the full Senate. The House Energy and Environment Committee heard and passed House Bill 261268 by unanimous vote. That bill would establish a process for local governments to designate disturbed lands as eligible sites for renewable energy projects. Specifically, that bill requires consultation with CPW on those eligible sites, and it includes formerly mined sites that were used for hard rock or construction materials mining as eligible. And so we are actively monitoring that legislation and working with our divisions to ensure that aligns with their respective authorities. And last, on the forestry front, the Colorado Strategic Wildfire Action Program, which is a part of the Executive Director's Office, just announced their 4th round of workforce development grants. They have a historic amount of money available, $6.9 million this year. And one of the awardees is a group called Teens Incorporated, which is an independent conservation corps. And they were awarded about $200,000 to complete the Crescent Meadows Phase 3 project in El Dorado Canyon State Park, which we're excited about. And last, I'll note that the Ponderosa Mountain Pine Beetle Task Force, which was called for by the governor in late December, held its kickoff meeting on February 26th. And the first in-person meeting of that group will be on April 1st and will include a tour of forests currently impacted by mountain pine beetle. So we're excited to see that group start to work. And that concludes my prepared remarks. I'd be happy to answer any questions you might have.
Thank you so much for the fulsome report. Questions, Commissioners?
Could you tell me again about the El Dorado Canyon?
Yeah, so CoSwap, which is a program within the Executive Director's Office, makes grants for wildfire mitigation projects and workforce development projects. And one of their workforce development projects in El Dorado Canyon State Park is going to this group called Teens Incorporated. It's a multiple phase project, and this is phase 3. And those kinds of grants both achieve wildfire mitigation goals and are intended to develop skills and training largely among young people through conservation corps in forestry and wildfire mitigation and those kinds of projects. So we're really excited about that. I can get more information about it for you if you'd like more.
Good, I'd like that. And the second question I had is, how did they define disturbed lands for alternative energy?
Sure, I can share the language with you. There are a number of definitions. They include brownfields. So those are sites that are regulated either by the US EPA or CDPHE that have former industrial uses of various kinds. So that's one category of eligible sites. A second category is formerly mined lands. And so that's where those are sites that would have been under Division of Reclamation and Mining Safety Authority, one of our divisions. And then I think there are a couple of other categories. One of the categories that the committee considered is former oil and gas sites as well. And so that definition is still being worked on. There were some amendments in committee yesterday, but I'll share that information with you. I think broadly the idea is sites that a local government could look at and say, we think that's the right place for renewable energy. And if chosen as an eligible site, then there would be incentives for renewable energy developers. But the authority to choose those sites is with local governments. But I'll share more with you.
All right. Thank you very much.
Thank you.
Now, I'd like to go to our first final action item. Welcome, Crystal Granda. And before we start our session, I'd like to remind everyone we really appreciate and invite public comment, both in the room and online. In matters that have a lot of interest, we respectfully ask for folks to limit their public comments to 2, maybe 3 minutes each. And would ask that if your comments have already been made, we would love to not be duplicative, just in the interest of keeping the meeting running according to time schedules. So with that, let's get started.
Good morning, Commissioners. Crystal Granda, Minerals Director. I'm here today to talk about an amendment to Lease 106456, also known as the Lowry Lease. And I do have representatives from Crestone, Peak Resources / SM Energy here today. So if the board has any other questions, they're here as well. So we're here today to update the tier map to match existing surface conditions. That is our goal. I think the board is pretty familiar with this lease. It's in Arapahoe County, and this oil and gas lease covers 21,000 acres. A little background, the oil and gas lease was issued in 2012, and there is an attached tier map that the intent was to guide where development occurs and avoid sensitive areas of the ranch. The tier map was created with the land board staff, the Nature Conservancy, and Arapahoe County. They all collaborated together to make this tier map. And the impetus for being here today, we negotiated these recommended changes with Crestone based on a water court decree that removed some reservoirs that were previously adjudicated on the ranch. And they're no longer adjudicated, so we'd like to remove those reservoirs from the ranch map. So I thought it'd be easiest just to visually walk the board through what is happening. So this is a map and also shows the tier structure. So there's tiers 1 through 4. Tier 1 is the most restrictive, no surface occupancy here in green. And tier 4 is the preferred surface occupancy, and you can see it's here in pink. The first change that is being made, you can see these 3 white hashed reservoirs. I've circled them here. These are the Rangeview reservoirs that no longer are adjudicated. So these 3 reservoirs were previously adjudicated, and per the terms of the lease, any Rangeview adjudicated reservoir is tier 1. So these previously had tier 1 status, but now they are no longer adjudicated, so we are removing these 3. The second thing that we are changing is this purple reservoir that's outlined here. That is was a planned East Aurora reservoir. That has been abandoned as well. We have multiple times contacted Aurora, but then recently confirmed with them again that that reservoir is being abandoned. And so we are removing that from the tier map as well. So this purple boundary, and previously it used to be tier 1. And the final thing I've circled, do you see there's a little orange square here? At one point in 2017, the prior owner of this lease, ConocoPhillips, was looking to put a pad site there. And so they came to the board previously and asked to make this tier 2, because it was previously tier 1 since it fell in with within this corridor here of tier 1 lands. The board approved that, and so we carved out this area for a pad. That area is no longer being considered for a pad, and so staff would like to revert it back to tier 1. So this is a map of what, this is an image of what the map looks like today. I'll walk you through a couple additional changes that we're making. So I've circled the 2 reservoirs here. These are the 2 Rangeview reservoirs that have kept their adjudication, so they will remain on the map. And in a meeting with Rangeview, they asked if we could put a 250-foot buffer around the reservoirs that was tier 1 to protect them. And Crestone agreed. So as you can see on this map, there is a purple outline showing that 250-foot buffer. And I've circled here where those abandoned reservoirs are. And although the lease defined what tier each reservoir was going to be, it didn't say what tier it becomes if they are removed. So staff had to do the evaluation and try to determine what we should make the land under those removed reservoirs. So that's really what we're focused on here today. So I've circled here what staff decided. In the current lease, there is a definition that tributaries to Coal Creek and Box Elder Creek should receive a tier 2 designation 200 feet on either side of the center line of those tributaries. Staff felt that these identified tributaries that I've circled here are more important to the ecosystem out at Lowry. And so they are trying to bump up that tier and have requested a tier 1 designation to protect those tributaries and a 500-foot setback on either side of the center line. This also falls in line with ECMC regulations as well. And so what I've circled here, you can see in green, we are bumping up from a tier 2 to a tier 1 and 500 foot. And Crestone has agreed to these changes. We have talked with them about this. And so this would be, and going back, everything else under the reservoirs that is not the tier 1 would be tier 2. That's what the recommendation is. So this is what the final map would look like. Some other considerations. Staff spoke and met with CPW and presented the map, and they support the changes that we're recommending. We also met with Rangeview to confirm the location of the 2 adjudicated reservoirs after the water court decree. They confirmed the location and had no objections. And then all of the changes that we're describing were made in accordance with the lease terms, the adaptive management provisions, and the 2-tier acreage requirements. So I have the board order here, and that is the recommendation. The board has any questions for me or for Crestone, they are here as well.
Okay, I think maybe you can welcome up your panelists you wanted to.
I think they were here if there were any questions. Yeah. Unless, do you have any prepared remarks or no? Okay, okay.
You've outlined it pretty clearly and the maps help a lot.
I just had a question, because you mentioned TNC was involved too. So what was the process for looking at all of this and coming up with this new structure, the new tiers?
Gonna see is Mindy, I was gonna say, it happened before I was here, but Mindy was here during that time.
I'm Mindy Gott-Sagan, the Stewardship and Ecosystem Services Manager. So I was very involved in that process back in 2012. We were looking at a way because the Lowry properties in the Stewardship Trust, or a good portion of it is a way to protect the natural values for which the property was designated. And so we worked with the Nature Conservancy. We also hired an environmental consulting firm, ERO, to work with us as well, and came up with a way to steer development away from the areas that we wanted protected and into areas that were already listed. And as a way that worked exceedingly well. But it was a series of, like in terms of the exact process of working with the Nature Conservancy and other organizations, was really a series of first identifying what we wanted protected, looking at what were reasonable boundaries or borders for those areas, and putting it into a tier system where we absolutely didn't want development to happen, where we did want it to happen in a kind of an incentivizing way of every acre that was developed within the lower, the 2 tiers that were development could happen, tier 2 and tier 3. The oil and gas developer, at that time, we didn't know who that would be incentivized to locate all facilities within the tier 4, which had already been disturbed. And that's worked very well.
And if I could just provide some historical perspective to that, because I was with the Nature Conservancy and was actively involved in this process. And if I'm not mistaken, it was part of this asset, the State Land Board and others knew, even with the recommendations to go into the Stewardship Trust, was a complicated multi-use property just at the outset. And so the asset management process was one of, again, optimizing for all the values. Nature Conservancy provided the science and the conservation planning to identify those natural resource values. And the entire process of the asset management, the regenerative grazing, and the tier map were the illustration of all those inputs. And it really was a very effective process. So
That's helpful. Thank you.
Sure.
Yes.
So sum total, high level, is it correct to interpret that we're enhancing the protection? Or is it well, I guess I'd start with that question, enhancing the protection.
We're enhancing what the lease terms they would say that those tributaries should be 200 feet on either side of center line tier 2. And we are increasing the protection to tier 1, no surface occupancy, on 500 feet on either side of those tributaries, because staff identified them as important to the ecosystem there. So, yeah.
And is it can you provide any clarifying discussion about our role or jurisdiction, I guess is the word, jurisdiction and an authority as compared to ECMC jurisdiction and authority?
So ECMC is the regulatory agency and we defer to them for all regulatory purposes. So in terms of, we have approved a surface use agreement for various sites out at the ranch, but ultimately Crestone has to go to them to get a permit from the ECMC, from the county, just like any other, we're just like any other landowner in that regard. So they still have to go to the regulatory agencies to get their proper permits with them. Is that what you're asking, or?
It helps a little.
Yeah.
Part of my ongoing education as a new member of this board.
Yeah.
You also have, as the landowner, the ability to set restrictions that may exceed the ECMC rules. And in fact, at the time that the tier map was developed, these regulations or these guidelines, the setbacks did exceed what ECMC required. Since that time, ECMC has updated their requirements. The changes that are in the tier map now are basically looking at the areas that we had to put as tier 1 because of prior lease obligations. Now that we've been freed from them by this water court decree, we were looking at what would we have put those areas in as a tier 1, tier 2, or tier 3 without those obligations. And I think, if I'm not mistaken, Crystal, we're using our standard setback has actually been exceeded now by ECMC of the 500 feet. Is that right? For the new tier 1, for those stream borders?
I mean, the 500 foot is in line with ECMC recommendations for non-public drinking water. I don't know if that's, yeah.
I don't know if that answers your question, but we obviously have to follow the ECMC rules as they exist now. But at the time, we were able to, as the landowner, we can set certain property restrictions.
Thank you, Mindy.
Okay.
Assistant Director Smith.
Yeah, thank you. I'm Christopher Smith, Assistant Director for Energy Innovation. To maybe answer both of Commissioner Pribble's questions in terms of acreage, tier 1 is increasing by just under 1,400 acres, and that's almost entirely coming from tier 2. So we're actually going up in tier 1 acreage. The other thing I'd like to clarify is, as Crystal said, we're not the regulator. This is a lease agreement, and this is an amendment to a lease agreement. So it's a binding contract that we have with Crestone, and so this is a negotiation between the two parties. It's not something that we just dictate. So
Thank you for the clarification. All right, well, I think that it would be appropriate to open it now to public comment. I encourage people in the room to raise their hand, and also people online to use the raised hand feature. Come forward, thank you. If you'll introduce yourself for the record, that'd be helpful.
Absolutely. Good morning. My name is Jamie Jost. I'm from Jost Energy Law, and I'm here representing Crestone Peak Resources Operating. Well, good morning, Commissioners, staff, council, and members of the public. Again, my name is Jamie Jost. I'm the managing shareholder of Jost Energy Law PC. I represent Crestone Peak Resources Operating LLC on matters relating to its oil and gas development on the 26,000 acre Lowry Ranch under Colorado State Land Board lease number 106456. So Crestone, through its predecessor ConocoPhillips, has been the lessee of the lease since its issuance on April 1st, 2012, and has continually partnered with the land board to develop the lease since that time to the benefit of the land board and its beneficiaries. According to the most recent statistics on the land board's website, the lease has generated $73 million in royalty payments, plus a $137 million bonus. Crestone is currently in the process of significantly progressing its oil and gas development under the lease to continue the substantial benefits to the school children of Colorado. The lease is now subject to Tier 1 map revisions, including planned reservoir modifications reflecting the evolution of range of use plans over the past 15 years, as well as additional protections for lands surrounding the center lines of tributaries before you today. While Crestone had not originally planned to speak at this meeting, it was made aware of public comments from Save the Aurora Reservoir, or STAR, only yesterday, and such comments warrant the following statements for purposes of the record as well as for your consideration. The first being that any modifications to Tier 1, as proposed by STAR, from the attachment 1 tier map in lease 106456 presented to the land board today would be contrary to Colorado Energy and Carbon Management Commission's siting regulations and Rule 604 that require 2,000-foot siting from the nearest residence and the nearest school. The ECMC is the agency that regulates oil and gas development near homes and schools, and the land board should refer any of STAR's concerns to the ECMC. The land board is the land management agency. It's not a regulatory agency and should not put itself in the position of being a duplicative regulator, as noted by board members during the work session yesterday by entertaining STAR's request. STAR's request for a 2-mile Tier 1 no surface occupancy from residences and schools is an attempt to impede oil and gas development under the land board and Creststone's valid and effective lease, and an end run around clearly defined ECMC and Arapahoe County regulations. STAR is not a party to the lease, has no authority or governance over the land board or Creststone's rights or obligations under this lease. In fact, STAR's comments and positions could be viewed as intentionally interfering with the land board and Creststone's contractual relationship to the detriment of the land board beneficiaries. The second point is any modifications to Tier 1 as proposed by STAR from the attached 1 tier map, again, under the lease, presented to the land board today would be contrary to the land board's mandate under Article 9, Section 10 of the Colorado Constitution that requires the land board to comply with valid land use regulations and land use plans. STAR's motivation for the submission of public comments is to prohibit Creststone's development of the State Sunlight Long oil and gas location, which is to be located in Section 27, Township 5 South, Range 65 West, which is currently a Tier 2 controlled surface occupancy. However, the State Sunlight Long oil and gas location surface use agreement has already been approved by the state land board, but more importantly, it's already been approved by the local land use authority, Arapahoe County. The land board should not take action that would otherwise undermine Arapahoe County's local land use regulation and land use plan relating to the approved State Sunlight Long oil and gas location local government permit. Any evaluation of the land board and Creststone's 14-year oil and gas lease for purposes of compatibility as proposed by STAR fails to acknowledge and understand that the lease results in vested real property rights, and any attempt to limit the contracted allowable development under the lease would be contrary to the lease terms as well as the law. The land board should not unilaterally modify or amend the lease as proposed by STAR. Under the terms of the lease, Creststone has agreed to all proposed changes in the lease via the amendment. And as stated in the state land board packet staff comments, Creststone has also agreed to all proposed changes to the tier map as Ms. Cranda presented today. Creststone would not and does not agree to any modifications proposed by STAR in its March 9th, 2026 public comment. And finally, the staff recommendations on page 34 of the board packet should be acknowledged and adopted by this board as presented with no modifications requested by STAR. Staff has extensive expertise in the review and evaluation of the amendments to the lease, and the board should rely upon the recommendations to ensure that it continues to meet its mission as well as its constitutional mandates. Thank you for your time this morning.
Thank you for your comments.
Ma'am,
Yes,
could you provide me a written printout of that, your statement, please?
absolutely. sir.
Afterward.
Yes, I can.
Thank you.
Yes, thank you.
Have we any other speakers in the room,
We've got folks online with hands up too.
right? Nick, if you'll administrate that.
You bet. So I see 4 hands raised online, and what we'll do is we'll take those in the order that you raised your hand, and you're currently in participant mode or attendee mode, which allows you to see and hear what's going on. I'm going to make a couple of mouse clicks on my end and promote you to a panelist, which allows you to control your camera and microphone so that you can make your comments to the board. We do not have a real clear timer built into the meeting today, but as you heard our board chair ask if you wouldn't mind trying to keep your comments to 3 minutes, we're certainly happy to have you do that. And I may do my best to let you know if you're running long on that time. But our first commenter, Marcia Kamen, you have been promoted and are able to address the board.
Thank you for giving me the opportunity to share my comments today regarding the Lowry Ranch tier map. I preface my remarks by saying thank you to the SLB staff for meeting with us to explain some of the details surrounding this revised map, but also the commissioners for grappling with the hard concept of balancing your mandate to be stewards of the land while generating revenue for schools. I bring your attention to the written comment from CU Law School that outline our recommendations for revisions to this tier map. While we are pleased to see the Tier 1 areas of land are expanded, we strongly feel that a 2-mile buffer zone of Tier 1 land around schools and residential property should be included. The CU Law comment explains and supports this request. My comments will focus on the issues affecting public health and safety. As community members have already experienced the impact of nearby oil and gas development, we feel compelled to share these firsthand situations to help you understand what life on the ground is like. Understanding the implications of cumulative impacts is critical when issuing leases on this property. While SLB does not have siting nor rulemaking authority, the entire process of having oil and gas operations located there starts with a lease from SLB. As you're considering the impact of your decision on this revised map, it's important to look at the whole picture, which includes the multiple well sites on this pad already. Knowing that Crestone has signed a lease to develop more wells out there, it's imperative that SLB learns from this experience when considering future leases. STAR has proposed to the SLB staff to partner together to assist in community-driven data collection, to scientifically record, analyze, and learn from this experience. Currently, residents are experiencing noise that's keeping them up all night from coming drilling at a pad, far from the homes. Residents are fearful of potential wildfires on the dry Piedmont grasslands. We can all be better stewards of this precious land with data-driven science. This board has discretion when approving new tier maps, and the staff has noted in the strategic plan they're in pursuit of more data. While SLB creates buffer zones based on ECMC rules for the newly approved reservoirs and tributaries, STAR seeks to understand the long-term runoff effects into the ground and waters. STAR has been pushing the ECMC for stricter rules to protect water, soil, and people. SLB is relying on ECMC to provide protection. Residents have already experienced a lack of monitoring and regular ongoing inspections while operations at Lowry continue 24/7. As numerous complaints have already been filed, we're quickly learning what our lives will look like for the next 20 years. You have incredibly tough jobs to make responsible, difficult decisions, balancing your constitutional mandate. I watched your strategic planning session and was impressed by your dedication and commitment to being good stewards of the land. Thank you for considering our input when making today's decision on the new tier map.
Thank you for your comments.
Next, we have Heather Emer. I'm going to promote you to panelist, and Heather, when you're ready, you're in charge of your mic and camera.
Sorry, guys, I'm not used to this kind of thing. Can you hear me?
Yes.
Good morning. My name is Heather Emer, and I'm one of the South Shore residents that backs up directly to the Lowry Ranch. My family and I relocated here from out of state for my husband's work during the summer of 2023. And we had no idea then that oil and gas sites were being approved behind our new home. Not a whisper from the home builder, nor from our realtors. And it wasn't even something we thought to look for moving into this beautiful master community. In February of this year, we started hearing a mechanical humming noise at night that we hadn't heard before. And at first we went all around the house trying to figure out where it was coming from and if something wasn't working correctly. Then we realized it was coming from outside. We started asking neighbors and they too were hearing it. Since mid-February, I have submitted 4 noise complaints to ECMC, 2 of which have already been dismissed with less than satisfactory reasons. You see, I didn't list the proper oil and gas site. We have heard that humming noise every night since early February with varying degrees of volume, but always loud enough to wake us up. And I've had to buy white noise machines and ear coverings so that we can get some semblance of sleep. But I haven't slept a solid night through since it began 5 weeks ago. I'm using so many things to try to drown out the noise that I'm terrified I won't hear any of my school-age children, my 3 school-age children, call out for me at night if they need me, or that I won't hear our smoke detectors or our house alarm if they go off. And I have to tell you, it's a terrible choice that I have to make every night as a parent, whether to get some sleep or to keep my family safe. And with wildfire season starting early, this choice causes immense anxiety in our household. ECMC believes that their current regulations are enough, stricter than other states even. However, I've been living with the reality of these regulations for the past 5 weeks, and I'm here to tell you that they are not enough. Not with the distance from our homes and not with the current requirements. And if ECMC were the ones living with this humming for weeks like we have and losing sleep, I know that they would agree with us that they need to be stricter, especially at night when people are trying to sleep. I am not here to impede oil and gas. I just want to sleep at night. We are already living with the health impacts of oil and gas operations with no guarantee that regulations will be updated to protect our community. We are exhausted, we are run down, and we need help. So I'm here today to ask you for all SLB lands that border residential communities to be designated as Tier 1. Please help protect Colorado residents from harmful health effects, as we cannot rely on current ECMC regulations to protect us. Thank you for your time and your consideration today.
Thank you very much for your effort to provide public comment.
Next on the list, we have Ann Hussein. Ann, you're coming on as a panelist, and you'll be able to manage your mic in a minute. Ann, when you're ready, we're ready for you.
Okay, thank you. Good morning. Thank you for the opportunity to speak to your commission. My name is Ann Hussein. I want to make a point that I'm speaking on my own behalf, on behalf of my family, and my home backs up to the Lowry Ranch cap. When we purchased, we were never informed that 8 well pads were proposed behind our neighborhood. The closest well pad will be 3,100 feet behind our homes if approved. Since learning about this proposal, I have closely followed the approval process and have watched Arapahoe County grant wildlife waivers and easements for haul routes while approving several applications nearby. Our community is already experiencing sleep disruption due to noise from existing well pads, some located almost 2 miles from our homes. Numerous complaints have been submitted to county and ECMC requesting a noise review. Residents in our neighborhoods are already losing sleep from constant nightly noises. When multiple other well pads are approved, it will significantly worsen the living situation for families in our densely populated community of nearly 2,000 homes. The cumulative impacts of existing industry are already significant. This situation proves what residents have consistently communicated to Arapahoe County and the ECMC. Current regulations are not adequately protecting our communities from harmful impacts of oil and gas operations located so close to our neighborhoods. Now, I understand that the State Land Board does not determine state regulations or final well pad sightings once the lease agreements are in place with operators. However, once the State Land Board designates land as Tier 1, counties and regulatory bodies should not be allowed to grant waivers, easements, or exceptions that undermine those protections. Allowing counties to accept financial compensation from operators in exchange for waivers on Tier 1 lands undermines the intent of these designations and places nearby communities at risk. Our communities are already bearing a disproportionate burden from surrounding industrial activities. Poor air quality affects our area throughout much of the year. Noise disturbances are already disrupting our sleep, and wildfire risk remains extremely high. Red flag warnings most days of the year. I just got an alert on my phone, critical red alert for my area. Still, well pad approvals just keep coming and no site is ever denied. Families live here, our children sleep here, they play here, they attend school here. Please consider the safety and the well-being of our communities as you allow leasing of our public lands. Our local and state officials have repeatedly failed to adequately protect us with current state and county regs. I ask the State Land Board to help safeguard our families and our quality of life by keeping all land within 2 miles of schools and homes in heavily residential areas as Tier 1 with no exceptions. Do not be swayed by money. Thank you for your time.
Thank you also for your comments and taking the time to make them.
I have one more hand up from Haley Young. Haley, promoting you to panelist.
Hi, thank you. I'm grateful to be able to speak today, and I wanted to address the suggestion that STAR's comments should be dismissed. Respectfully, our comments are entirely appropriate for this board's consideration. We're not asking the State Land Board to override ECMC rules. We're not asking the board to displace Arapahoe County's authority. Those are separate legal frameworks. The Land Board has its own independent constitutional and statutory duty to manage trust lands for the benefit of schools while also protecting the long-term productivity, natural values, open space, and wildlife habitat of those lands. You are a trust and yes, landowner, but SB 19181 moved Colorado law towards stronger protection of public health, safety, welfare, the environment, and wildlife, and it specifically recognizes regulation of surface impacts such as sighting and noise. We know that the residents and obviously also the wildlife and ecosystem residents of this land are experiencing light impacts and noise, and we're concerned about the cumulative impacts. And I think that is the emphasis here, is not that, because we do greatly appreciate this tier mapping change. We think that it is definitely appropriate, but there's also the consideration of how much development is going on here. And granted, there's also human developments and residences, and that impacts wildlife. So that is why the Tier 1 mapping along residential neighborhoods is also appropriate, because there's wildlife that is impacted and displaced from those developments as well. The noise and light goes much further than ECMC regulations can quantify for right now. So this is not an improper request. It is the kind of public input that the board is requesting and hoping to hear as you are working to serve the public. And we think that everything you're doing in the direction that the board is moving in, as far as including the public, is a very positive participatory change. Asking for more Tier 1 acreage based on cumulative habitat disruption, surrounding development, and substantial noise impacts to wildlife is a stewardship argument addressed to the right decision maker. The board has a responsibility to consider it on the merits and not dismiss it. STAR is not asking SLB to rewrite ECMC rules or override Arapahoe County. STAR is asking the SLB to exercise its own independent trustee discretion when deciding how much of this particular trust property should receive Tier 1 protection. Thank you very much for your consideration and for including public comment in your decisions.
Thank you for taking the time. We do appreciate hearing from everyone.
We have a hand raised from Wendy Hannafy. Wendy, going to promote you to panelist now. And when you're ready, you're in control of your mic and camera.
Okay, I'll choose to keep my camera off. Thank you. Good morning, members of the State Land Board. My name is Wendy Hannafy, and I'm a resident of Aurora, Colorado. I'd like to agree or thank the SLB for expanding their Tier 1 land designations in the area surrounding Aurora Reservoir, where wildlife concentrations are among the highest in the region. Aurora Reservoir and its surrounding open lands represent one of the last intact grassland and riparian corridors on the Front Range, Piedmont. Mule deer, pronghorn, migratory songbirds, raptors, and shorebirds all depend on this landscape, not just for food and shelter, but for the acoustic environment that allows them to communicate, detect predators, and raise young successfully. The scientific literature on this point is now unambiguous. Dozens of peer-reviewed studies confirm that anthropogenic noise from roads, development, and energy infrastructure measurably degrades wildlife habitat even when the physical landscape remains intact. Noise reduces the distance over which animals can detect predators and mates, elevates chronic stress hormones, lowers reproductive success, and can displace entire communities of birds and mammals from otherwise suitable habitat. Research has shown that noise in transportation corridors can shrink the effective listening area for predators by up to 70%. In open grassland systems like those surrounding Aurora Reservoir, where visual cover is limited and animals rely heavily on sound, these impacts are especially severe. Tier 1 designation offers meaningful protection by limiting the types of development and surface disturbance that generate chronic noise. Expanding that designation to buffer the reservoir and its associated grasslands creates a larger zone of acoustic integrity, one that reflects what the science tells us wildlife actually needs, not just what we can see on a map. The wildlife that gathers at Aurora Reservoir doesn't stop at the current Tier 1 boundary. The noise doesn't either. Expanding these protections is low cost, high impact step that benefits wildlife, supports long-term biodiversity on the Front Range, and preserves the character of a landscape that Aurora residents deeply value. Thank you for your time and your service to Colorado's land and wildlife.
Thank you for your comments. Nick, do we have any other?
We have Brian Matisse, Brian promoting youth panelist now. And this is the statement from Ms. Jost that was requested.
Thank you, commissioners. This is Brian Matisse. Can you hear me?
Yes, thank you.
Thank you. I'm Brian Matisse. I live in Southeast Aurora in the Tollgate Crossing subdivision. I want to appreciate the efforts that you made, a good faith effort to try to change these Tier 1 boundaries, which will require due to the change in reservoir locations. The concerns I have are twofold. First of all, the concern I have is that it seems as if some of the boundaries around the proposed new reservoir were chosen in good faith, but nonetheless without an adequate study as to whether the boundaries around the proposed reservoir were sufficient to include the riparian areas and the wildlife that would be affected within those areas. It seems as if this was perhaps rushed a bit, and there needs to be a more thorough study as to exactly what those boundaries should be. The second concern that I have, which is very important, is that with the change in the locations of the former reservoirs, there does not appear to have been a thorough consideration also of the effects on the stream flows that would be in that area. In particular, the possibility that these stream flows would affect the existing riparian areas. And so before abandoning those areas and changing those boundaries, I think it's necessary to conduct a more thorough evaluation. So the concerns I have is that it's primarily premature at this point to make these changes and designations, and I think that there needs to be more study. There needs to be a more thorough evaluation of what the effects would be before these changes are made. Thank you once again.
Thank you too for taking the time to provide your comments.
Commissioner, at this time, there are no other hands raised.
Okay. Crystal, can I ask you to come up and just if you have any comments from the work on this relative to the process of setting the boundaries and the consideration?
Sure. Can I call Lindsay? Yes. When I worked with Lindsay Brandt.
Good morning, Commissioners. Lindsay Brandt, Biodiversity Program Manager with the State Land Board. I guess the comments I will add, unless you have a specific question.
No, just
when, Crystal kind of communicated that these reservoirs were no longer going to be built because of all of the water court things that have happened. We really looked at, okay, we have basically a tier vacuum here. We don't know what these tier lands can be. Because we do value those drainage ways and those riparian zones, we thought at least where the reservoir was that was already tier 2, we ought to keep that tier 2 within that drainage corridor, because why change it when it's already I'm sorry, I said tier 1. Yeah, I meant to say tier 1. And then we also, so as has been mentioned, you cannot under current ECMC regulations develop within 500 feet of a drainage way. However, we have a habit at the land board, maybe we shouldn't do this, but we tend to roll out the tier map and use it for other things when considering other activities and other uses on the ranch. And so we thought by adding that tier 1 buffer along those drainage ways or maintaining it in certain locations, would kind of serve us in the long run in terms of as we consider other activities that may occur on Lowry, we kind of have that guidance, if you will, of, we've identified these as important drainages that we should limit development near them. If you look at the tier map and you see some of the drainages that are kind of the tier 2 drainages, they're all more like upland swales, they're kind of grassy swales, whereas the drainages kind of below where these reservoirs were originally proposed have a little bit more, it varies by the drainage, but they have more actual riparian or wetland type vegetation in them. So they provide a greater benefit, to the larger ecosystem.
That's helpful clarification. Thank you. Commissioners, any more questions, clarifying questions for Lindsay or Crystal? All right. Well, now as a refresher, what we'd like to do, having concluded public comment, is there's a motion in front of us. And perhaps we can put a motion on the table that would enable our discussion of this matter. And then we would take a vote on that motion. Yes, Commissioner. Okay.
So I guess I have a question of the chair, just procedurally. I have a question for Crystal.
Oh,
would I
for
ask that
Crystal.
later or now?
No, now is the time for that.
Okay.
Yes.
So for a designee from Crestone, several of the folks mentioned that in the past 5 weeks there's been exceptional noise. Is that operationally something that was just happening for a short period, or can you speak to that?
Sure. Our closest operation right now is at the State La Plata well site, and I'll go back to the mapping.
Can I ask the witness to identify yourself first?
Well, I'm sorry. I'm Dan Arrington, Asset Development Manager, SM Energy. Crestone is a subsidiary of SM Energy. The State La Plata well site is in section.
You can use that mouse.
Oh, is this one?
Point right? Yeah.
Maybe. It's kind of in this area right here.
Where's the housing in relation to that?
That is the housing there. That's the closest housing. The individuals who spoke, I don't know exactly where, but this is the closest neighborhood. That site was drilled earlier this year. The rig has left that site and it's currently undergoing completions operations. It is still undergoing completions operations and will be for approximately 1 more month.
And is that the noise that they're hearing is from this that will be concluded in a month?
I can't speak to what the noise they're hearing is. I do know that we've received the same complaints via both the county and the state. We have both sound protections, 32-foot engineered sound walls to reduce noise, as well as sound monitoring stations. There's a sound monitoring station just south of the pad, approximately here. Our sound engineers have analyzed what that sound station heard relative to, and then extrapolated that sound signature out to where the neighborhood is, and have found there's no non-compliance with the regulated limits.
While he's here, anybody else, any other commissioner have any questions for SM Energy?
So I guess just follow on that. So do you have a procedure where you can work with residents and at least a discussion about when you might have periods of exceptional noise and they can understand the timeline?
Yeah, we do publish our timeline for operations at each of these sites. So this site, we will be done in about a month from now. Again, I think I take exception that there is exceptional noise coming from that site, given the data we have from our sound monitoring station. And we're obviously committed to being compliant with the regulations at times, both county and state.
Commissioner Harvey, I see you have a hand up.
Yeah, and I don't know if she's still online, but I think one of the commenters, Ann Hussein, mentioned a critical alert. Anyone know what that's about? She said she just saw critical. Was that an air alert?
A high wind.
It's high wind. We all got it.
Yeah.
Oh, high wind.
It's
Okay,
high
got it.
winds.
I thought it, okay.
The front
Okay.
range is under high winds and it's a red flag warning for fire danger.
Okay. So I'm hearing two sort of compelling things. One is, these residents,
Commissioner Harvey,
very,
Commissioner Harvey, can I stop you for a second? Because I
Sure.
think you're going to make some really good points, and I think it'll be
I doubt it.
more appropriate for the discussion between commissioners.
Sounds
So,
good. Thanks.
Unless anyone has any further questions for SM Energy, you are released. Thank you. All right. So now, to commence the discussion, it would be useful to have a motion on the table. We have a board order in front of us. We'll then have the discussion and then we'll vote yes or no on that motion. And there's the possibility of other motions, but we do have a board order in front of us.
Madam Chair,
Yes.
I move the motion as contained in great length on page 36 of the board packet. And I'm only going to extrapolate a few sentences. I'm not going to read the entire thing because I'm confident council can record, cut and paste all of this verbiage. In any case, I move that the board amend lease 106456 to replace existing attachment 1 to the lease with the updated Lowry lease tier map attached and is exhibit 3 and support changes to the lease language, etc., etc.
Thank you very much, Commissioner Pribble. We have a motion then to approve the board order as presented in our packet and summarized by the commissioner. May we have a second?
Second.
Second from Commissioner Scanlon. And so now maybe going back to you, Commissioner Harvey, you are about to synthesize brilliantly some thoughts.
I doubt it. So I guess I'm hearing two kind of, compelling things. The citizens of Star Community, a number of them sure sound unhappy with the noise and the development. And hearing Crestone and SM Energy saying that they're within compliance. And so I just want to make sure I understand what we're voting on. We're voting to increase some acreage in terms of protecting it with tier 1, but Star Community would like it to be bigger than what we're suggesting. Is that, am I understanding this correctly?
I believe that to be true.
Okay. anyway, it's just kind of interesting to hear, the public comments that they are really being hit with this noise, and the energy companies saying they're within compliance. So I don't know what's true here, but I'm hearing two different things.
And it's possible that both things can be true.
Mm-hmm.
Commissioners, sort of thoughts as you reflect on this?
I guess adding one more thing, I certainly support increasing tier 1 protection. And I don't know that we could, I don't know exactly if we have any authority to vote on what STAR wants us to increase it to.
Perhaps I can share some of my comments, and that might illuminate a little bit what you've asked. So on this matter, from my point of view, and Counselor can correct me, we are voting on whether or not to approve an amendment to a commercial contractual lease. And the lease has benefits to us in terms of protecting, offering more protection than we had before under this operating lease. The observations I have is, in part due to my history with this, is most of the operating lease predates a majority of the housing. And I guess what I come to think about here is, I think it's incredibly unfortunate that developers can develop grasslands, take away habitat, provide houses, and not necessarily tell people what's going on in the general neighborhood. So if we want to look at where sort of some big issues happen, I think the people who relied upon representations from developers in buying their houses, building their houses, that is something, for others to consider, but I'd like to raise it. The other thing is that if we have stated in our workshop, as mentioned, also now, we have regulators in the state. They have the duty to balance and manage concerns of people and business in our state. We are not those people. We are subject to those regulations, just like our lessees are. So again, I'm delighted to hear that STAR is taking their very real evidence and issues to the appropriate authorities. The third thing I'd like to say is, if we elect to not vote for this amendment, the existing lease will stand. There will be no amendment, and there will be no change in the tier status. We'll have a bit of a clunky map that has things on it that aren't real, but we will have the protections as they sit today with that lease. So those are, I hope, clarifying points for the rest of the commissioners. And I guess the final thing I say, learning from past experiences on this board, Commissioner Harvey, to your point, we could consider as a board to instruct staff to negotiate further with our contract lessee from 2012 and try to improve the protections. That seems like a speculative endeavor, but I'm not going to pass judgment on it. But that would be an alternative motion, I suppose, or an alternative direction to staff. But at present, we have before us an amendment to an existing lease that changes a tier map, which also affects, as Lindsay pointed out, all other uses within the Lowry Ranch pursuant to the asset management plan. And so that is the motion we're debating.
So, Madam Chair, a question to you. Twofold. What you're offering an interesting voice to the petitioner's concerns, the residents' concerns. What form or what nature, I guess form is probably the more correct term, would those improvements or amendments other than added to this amendment take? What would it look like? What would it be?
I'm not sure I'm following your question.
You suggested that the board could contemplate an instruction to staff to address the neighborhood concerns, right?
Yes, so
What would that look like?
I have no idea, but it would be, we know what has been negotiated right now, which is the map you saw and the increase in the tier 1 protections. So that's kind of what the parties have agreed to now that we would approve today. If we didn't think that was enough, then we could vote down this motion and we could direct staff to negotiate with SM Energy something beyond the protections that we have presented, or the staff has presented today, leaning more towards some of STAR's recommendations of up to 2 miles.
Okay, well, rather than get too tangled up here, but I'm afraid we already are or will. I don't see the need to necessarily quote vote down this motion to provide an instruction to staff. This amendment or this motion and is an improvement in the protection as it exists currently. So I see no argument for defeating that, merely to replace it with an instruction to staff to do something more. Then the second question you run up against, which I would ask staff and council to address, is what jurisdiction we have as a leaseor to provide further protections, whatever they might be. Implied in the complaints from the neighbors is a desire for greater setbacks. Number one, that ship's kind of sailed because the well is drilled. Number two, it's not within our jurisdiction, as I understand it, to require greater setbacks. So I'd be curious to know what jurisdiction to improve upon this amendment there is.
In my opinion, and I can be corrected by counselors, I don't think it's a matter of jurisdiction, Commissioner Preble. I think we, as a private party, essentially for these purposes, as a landowner, we can negotiate whatever deal we want and ask for extended protections as we would desire. Wouldn't be jurisdiction, it would be just a negotiating objective, if you will. I believe staff held closely their objectives to maximize protections in their prior negotiations with the lessee. So I don't think it's jurisdiction. And I like to think that the state land board, and we have indeed seen in other cases that we have a tradition of holding our lessees to a higher standard for ourselves than just relying on the protections that regulatory authorities have put forward. So I believe our organization attempts to do that. So in short order, it would be, there's nothing that prevents us as a private owner and lessor of mineral rights to add protections should the parties want to agree.
All right. Well, in defense of the motion that I made, I would continue to propose passage of this motion, or promote the passage of this motion as contained here, and invite you to make a motion subsequent to that to implement the remedy, or to invite further remedies downstream, to the extent we have the jurisdiction to do so. I mean, I share what I hear here from Commissioner Harvey, and I'm sure we all probably share, since we're all or many of us rather, not necessarily all, are well aware of the longstanding controversy with oil and gas development adjacent to densely populated suburban, exurban areas across the Front Range and the I-25 corridor, et cetera, et cetera. It's not new. It's been going on in this state for 30 years at least that I've lived here, 35. So I like the idea of pushing the envelope of what can be done to increase the protections for residents, and we all have sympathy for them perhaps being snookered by residential developers, but that's beyond our jurisdiction and capability to remedy. So once again, I propose and call the question on this motion, and I invite you to frame yet another motion should you desire.
Thank you. Commissioner Scanlon, I think you had something to say.
Yeah, I think we're in a little bit of a corner here because we have a lease and we have to abide by the terms of the lease. So these folks are allowed to drill on this property. And I'm not sure, what I do like that staff has done is they've increased tier 1 for us, which is, I think, one of our goals. I'm not sure how you can manage more. We have to abide by the terms of the lease that we have. I'm not sure how much more finagling we can do with tier 1 that still adheres to our lease. So I don't want to get us too boxed in. And I think what Star would like is all of this to be tier 1 if they could, and I understand that desire. So I'm not sure how much further we can push that tier 1 status, which tier 1 effectively rules out drilling. And so I think that's the quandary that we face. We have a standing lease. We are legally contractually obliged to adhere to that lease. We're trying to increase the tier 1 acreage that we have while still meeting the terms of the lease. And I'm not sure there's much more room to move, Jim.
Well, I'm not the one that made the suggestion.
Well,
the chair made the suggestion.
I get it. So I don't mind asking Crystal if there is much more room. And these are long-standing debates. ECMC deals with this every day. And so setbacks, et cetera, are something they negotiate as they do their permitting, et cetera, et cetera. So it's not a cut and dry issue. Just because they want to drill somewhere doesn't mean they will get to do so. That's an ECMC question. Whether or not our tier status allows it, that's their jurisdiction, as you were saying. But it is something that I'm not sure how we can checkerboard this property in a way that doesn't conflict with the lease terms. So I'm just not wanting us to, we have some constraints. That's all I'm acknowledging.
And before you answer, I just want to say that had we not had a water court decision, had we not had a rearrangement of reservoirs, we wouldn't even be having
this conversation.
The
We
lease
wouldn't have
is-
been able to add more tier 1 to it.
The lease is valid, it's operating, whether we like it or not, that's what
It's
we
what it
have.
is.
And therefore, this amendment is taking advantage, in my view, of an opportunity that we didn't even create for ourselves, that we now have to vote on.
Well, Madam Chair.
Well, I need Crystal to
And
answer
also-
my question.
I was just.
I'm just want to speak to that.
Yeah.
Because I don't think it's fair to ask her to answer that question, right? I mean, there's a lot of anticipation about what else we might do. I'd like them to study it or come back to us, but it just feels like right now, it's a lot to ask them to respond to that question without.
I feel comfortable responding if.
Well, okay.
And then I was just gonna say, in terms of the lease, we can't unilaterally change it. Crestone has to agree, and I think they came up here and already made a statement that they don't agree with what Star is requesting. And they have agreed to the changes that we brought forth. And I also wanted to say that, when we made the tier map and the considerations that Lindsay's giving, a lot of these are related to our fiduciary duty of keeping the long-term economic productivity having good stewardship of the land. And we're not focusing our tier map on like public, the protections of the public as they want. So our tier map is for our purposes for land stewardship, and we rely on the ECMC of protecting the public. So I just wanted to.
That's well put. Commissioner Harvey?
Yeah, this conversation's been really helpful, and Commissioner Pribble cleared it up in my mind that we're voting to increase tier 1 lands, and voting this down isn't going to help Star Community. So it's to me it's sort of two very separate issues.
Yeah.
So thanks. This conversation has really helped.
Then pursuant to your request to call the question, Commissioner Pribble, before we do that, does any commissioner have anything else to add for the record or any other thoughts or questions?
I would just add for the record, I understand the community's concerns. I totally get it. We've been to a well site when they're drilling. It's loud. And I understand the regulations and the sound buffers, but it is loud. Thankfully, it does end, but there's ongoing considerations. And I think they're all valid. So I don't envy ECMC trying to manage all of that. But I want to acknowledge their concerns. But I do appreciate the framing that's been offered, that we have a separate issue in front of us, and I want to take advantage of the moment to add more tier 1. So I just wanted to put that out there. I appreciate staff's work in negotiating this thus far.
Thank you. And now I'd like to call a vote. Commissioner Pribble, and this is a vote on the motion on the table. This was seconded to approve the board order as contained in our packet. Commissioner Harvey, how do you vote?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Yes.
And the chair votes yes, motion carries 5-0. And thank you everyone for your participation and your comments, especially all the online commenters.
And I can't resist commenting that while you've talked about residential developers coming into sites that already have a contract, it is up to local officials.
I was going to say the same thing.
And it's important to note that this lease was established and is confirmed prior to this housing development ever being proposed.
Yes, right. And that development was approved by local officials.
Exactly.
And maybe that shouldn't have happened. I mean, at some point, there's a rub.
So it's just on notice to local officials.
Thank you for
Yes.
saying that very.
I was going to say the same thing.
Yeah.
I appreciate you articulating it much better than I would have.
Yeah.
Thank you.
Well, thank you, everybody, for. Commissioners, are we good to keep going through a few more business items, or would you like a quick break? You all right? Well, then back to the Lowry Ranch.
Just give me a second.
But I am sympathetic. It would be the pits. It's like people out here, I mean, they just have it. They honestly, it's coming out with their kitchen views and it's.
All righty, welcome, Ms. Brandt.
Thank you. Again, hello, commissioners. For the record, this is Lindsay Brandt, Biodiversity Program Manager, and I am here to talk specifically about the Lowry Ranch Management and Enhancement Account. In short, we have an opportunity to advance the stewardship part of our mission at Lowry Ranch by spending about $165,000 over the next 2 years. Quick side note, all photos in this presentation were taken at the ranch. By now, I think we're all very familiar with the location of this property in Arapahoe County. In total, it's about 26,000 acres, 21,000 and change of that is in the Stewardship Trust. And as we are well aware, it's located just east of Aurora Reservoir. So interestingly, we've already kind of covered a bit of the history of the oil and gas lease at Lowry, which was approved by this board in 2012. And at the time, so that lease is now held by, at that time was ConocoPhillips, now Civitas or SM Energy. At the time that lease was approved, this board really wanted to put emphasis on our stewardship responsibility at Lowry. This oil and gas lease was the first property-wide oil and gas lease I guess the only property-wide oil and gas lease. There are a few kind of one-off leases. But they took some of that bonus payment that was mentioned earlier, and they took $3.5 million of that lease bonus payment, and they put it into a special account to fund stewardship projects. And this is what we call the Lowry Ranch Management and Enhancement Account. And the idea of this account was to leave the principal intact, but spend the interest to fund stewardship projects on the ranch. This is just a list of some of the projects that have occurred using these funds. Staff has spent about $255,000 to date out of this account. In the early days of this account, the board actually gave permission to spend down the principal a little bit, since it took a while for some interest to be generated, but that balance has recovered. So there's been about a dozen different projects such as these done on the ranch since 2012. I do want to note the last item on this list, the grassland bird studies. The board approved some funding for this back about a decade ago and again in 2023. And we look forward to bringing the results of these studies to you later this year. So the current account balance is $4.1 million roughly, and subtracting that principal leaves about $623,000 available for stewardship projects. Today, we're requesting permission to spend $165,000 for use in our integrated weed management program at Lowry. This funding will be used on two primary efforts. As you know, weed management is really never finished. It's an ongoing effort. Introductions come in with wind, carried by wildlife, waterways, vehicles, and equipment. We have several ongoing weed management efforts on the ranch currently. We implement cultural control by maintaining healthy and resilient plant communities that are more resistant to weed invasion. We develop site-appropriate seed mixes to be used for revegetation. Our grazing manager is, exemplary at this ranch, and he helps us with targeted grazing efforts to reduce weed populations in certain areas. We also are implementing biological control at the ranch. We have a partnership with the Palisade Insectary, where they've established populations of leafy spurge beetles. These photos on the left was provided by the Department of Ag, and the right is actually a beetle collected at Lowry Ranch. These are all species in the Aphthona genus. And this introduction has been relatively successful in that CDA actually, or the insectary actually comes back out to collect beetles from Lowry and take them to other sites to be used as biocontrol
What do
agents.
the beetles prey upon?
Leafy spurge.
On leafy spurge.
Yes. Yes. We are also exploring opportunities to introduce the diffuse knapweed weevil at the property as well. We also focus on prevention. We require lessees and contractors to properly clean their equipment and vehicles prior to moving on or around the property. And then many of our leases require our lessees to implement noxious weed management in association with their operations on well pads, pipeline corridors, roadways, etc. We used to hire contractors to do weed management at the ranch. Several years ago, staff made an effort to bring that work in-house. There was the idea that we could do it more inexpensively and efficiently on our own. It became quickly clear that staff does not have the time or capacity to go out and spray weeds at Lowry. So we really want to spend this funding on two main efforts. The first of these is to update the weed mapping effort that was last completed in 2012. This is just a screen snip of the map that was generated at the time. Weeds identified at the property during that survey was all the kinds of thistles, both Scotch thistle, musk thistle, Canada thistle, diffuse and spotted knapweed, leafy spurge, Dalmatian toadflax, and Russian olive. This new mapping effort would focus on B-list species, and C-list species would be mapped kind of opportunistically if they were encountered. The cost for this mapping is $65,000, and work could be completed this summer and fall. We will use this mapping data to really develop a comprehensive property-wide weed management strategy. Additionally, we already know of several locations on the ranch where there are established noxious weed infestations, and we'd really like to get to work on these areas as soon as possible. We've identified a contractor that is available to begin work this summer using GPS-equipped herbicide application equipment, so they can go out and treat noxious weed infestations and collect GPS data on those treatments simultaneously. So this will provide staff with a permanent record of where weed management has occurred, and will supplement those inventory efforts while also getting us a head start on managing some of these infestations. We've budgeted $50,000 a year for these efforts for the next 2 years. I want to stress that that is not enough to treat all the weeds on the property, but it's just kind of to get us moving in that direction until we get that mapping done and can kind of put together a more comprehensive plan. So in short, staff recommends that the board approve the use of up to $165,000 from the Lowry Ranch Management and Enhancement Account to fund noxious weed management as described in your cover sheet. And I'm happy to answer any questions that you might have. Here's a board order for your convenience.
Commissioners, questions? Looks like Commissioner Harvey.
Yeah, Lindsay, a couple questions. Why does it cost so much to map the weeds? I mean, that sounds like quite a bit of money to do that mapping.
You know, that's a great question. We worked with HWA Associates, which is the contractor who does a lot of the natural resource work on the property. So they're very familiar with the terrain and kind of what it takes to get around the property. They've been doing prairie dog colony mapping for us for several years. And so, you know, they kind of have a good sense of, you know, how much time it takes to cover the entire ranch. And they're doing this on the ground, you know, with the use of ATVs and on foot. So to really get in to all of the riparian areas, all of the drainages, and just, you know, cover that property visually is a significant amount of time invested, and also collecting all of that data. I think I mentioned in the cover sheet that we are eager to take what they find on the ground and compare it to what we can learn using our new Lens tool when we get that online, to kind of see how much of this, you know, could we potentially use some remote sensing options to do in the future.
And do you have any estimates of what you might use to control these weeds biologically, with herbicides, mechanical, et cetera? Do you have that estimation yet, or does that just come after the mapping?
You know, that'll be mostly after mapping. I think we will continue using those biocontrols and those grazing strategies and other strategies, but I expect some spot spraying of various herbicides will be also used, and then mowing, you know, in certain cases where if we can't get those treated at the right time, we might have to resort to mowing.
And I know they're expensive, but have you explored goats, you know, the industrial scale goat control where they bring a semi in and unload 200 goats?
Yeah, you know, we have not pursued that. I know our lessee, Nick Trainer, experimented with goats for a while for various purposes. And, you know, he said goats are fun and interesting, but they take up a lot of your time because they are smart and they are escape artists. And so he was like, you know, containing the goats nonstop when he had his goats out there. So it's potentially an option we could look into.
Yeah, so I was referring to, you know, the contractor who is responsible for the goats, not you guys. And then the last question is glyphosates. And, you know, there's certainly a lot of science saying they're not very good for you. So I'm sure you're aware of that, but I don't know where the state land board stands on those things.
Yeah, you know, glyphosate, or as we all know it as Roundup, one thing that I do not like about that herbicide, it's non-selective. So anything that glyphosate touches, you know, is ultimately killed. I think there's a lot of other herbicide options that are available that are labeled for the use in the state of Colorado that would be better choices. Many of those are labeled for use around aquatic areas, riparian zones, and some of those have a residual effect, which can, you know, help with germination of new weed species or new weed seedlings that provide, you know, much better options than something like glyphosate. And you know, that is one of the reasons the contractor that we're looking at using has the ability to do spot spraying, so they're not doing like an agricultural type boom spray application, but they're really just targeting the weeds where they occur.
Great, thank you.
Go ahead. I didn't mean to interrupt you, Commissioner
I,
Harvey.
I think we're good.
Yes, Commissioner Heath.
So I've two pieces of input. I would like very much for the land board to avoid using the whatever the Roundup equivalent is, or Roundup, and be on record that we're trying not to use that. There's increasing information that is a concern about using that on any land, private or public. And secondly, you know, in Boulder, we've used goats with special goat contractors who come in, do that, and then they take the goats back up and leave. And that's been a much more effective way. So I would encourage you to consider that again. I totally agree. Nick Trainer does not need to be the
He did
Pretty good.
I was gonna say, Summit counties use goats too. I don't mind approving this amendment. I wouldn't mind if you looked into goats.
Yeah. And when we, get that information that we will be getting this summer, we can certainly kind of roll that into our larger plan.
Lindsay, I have two questions sort of at maybe a higher level. One is, Lowry, one of the things that back in the day, even we all envisioned for Lowry was for it to be an incubator, a base of experimentation, if you will, to help the state land board experiment with things and then advance those practices. So one question or comment is, the good work we're doing here with experimenting with biocontrol and all these different methods, whether it's goats or whatever, and certainly a +1 on Commissioner Heath's statement. I think we have no business using glyphosate. But have you guys thought at all about how to, bring this information to other people to help spread weed control if it's just in the neighborhood along the Front Range? Any thoughts about how to do that?
That's a great point, and I think that's something we could definitely do. We have traditionally held various field tours at Lowry. Most of those have been focused around regenerative grazing.
Right.
I did speak with John Kaltenbach, who is I'm not going to say he's the director of the insectary, but he is one of the insectary staff that, has been working with us at Lowry for many years. And he wanted to bring some volunteers out this summer to help with the biocontrol collection. So I think there are opportunities, whether it's with CWMA or other organizations, to maybe do some of those types of tours and communication opportunities of the different things that we've done at the ranch.
Yeah, that's what I was thinking, sort of like workshops, like almost like we do with regenerative grazing. And then the other thing that struck me, and not necessarily that you should have an answer for this now, but for us to think about, I remember it was just so exciting that the $3.5 million was set aside for this purpose. And it seems, this is a good use, but it seems like we also have the capacity to do other very innovative and interesting things. So I wondered, if you're not already doing it, could we charge staff with thinking ambitiously about technologies we'd like to prove up there, approaches, really let's spend some money and test some things and see what we could learn. It may not be effective, for example, to do a mini solar thing. I think we're better off pairing with with some of the operators and doing our testing there and backstopping the risk. But there may be other things of particular technology that we could use there and export and influence others.
Certainly. Yes. I think we can definitely keep looking at that and hopefully come back to you with some more requests.
Spend some money. All right. Ben, is there any public comment on this matter?
Folks listening along online, you're here to make a comment on this item from our agenda, the Lowry Ranch Management Enhancement Account request. Please use the raise hand feature and we'll bring you forward so you can address the board. Folks in the room too. Although everybody in the room has a state.co.us email address.
Well, don't hold back,
I have one hand raised, Marcia Kamen. Marcia, bringing you to panelists.
Thank you. I appreciate that. I just wanted to give the board my praise because this is definitely warming my heart listening to this discussion. We truly appreciate the stewardship of this land and helping to take care of the weeds out there. And some of our members are texting me and saying, yes, put some goats outside our back doors. We would love that. So I just have to tell you that listening to you deliberate and listening to you talk and wanting more data, this is so heartwarming to know that there is a government entity that shows such stewardship for our land. So I just want to say thank you. We are so impressed because 3.5 years of participating in public comment and government entities, authorities, has not been a very easy process for us. And so sitting in on this one, it's a pleasure. Thank you from the bottom of our hearts.
And Martha, if you wouldn't mind, just for this segment of the record, state who you're speaking on behalf of as a we.
On behalf as a we is Save the Aurora Reservoir. When Haley spoke and said that we duly have the right to be here today. And you had said you welcome public comment. And so some of our members, some of the people today are just community members and we're speaking on behalf of themselves and actually stated that. I personally am speaking on behalf of STAR and I'm incredibly proud of the things that STAR has accomplished in the last 3.5 years.
Thank you for your comment. Appreciate it.
Nevertheless, she persists.
All right, so we've heard from public comment and it would be appropriate to have a motion for the board order in front of us.
Madam Chair, I move the adoption of the Lowry Ranch Management and Enhancement Account request as contained in the board order in our packet.
Thank you, Commissioner.
Second.
Commissioner from, second from Commissioner Scanlon. All right, is there any further discussion from the commissioners or may we vote? Looks like we could vote. Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Yes.
Chair votes yes, motion carries 5-0. Thank you very much, Lindsay.
Commissioners.
Really is not.
Good morning, Commissioners. I'm Mindy Gotze, again, the Stewardship and Ecosystem Services Manager. I'm here to present a Ecosystem Services production lease for your consideration and recommendation. The Arkansas Headwaters Mitigation Bank project is part of the Ecosystem Services production lease 118010. And I'll also be presenting a road access permit 118084. Both of these items are coming to you because of the policies for the Ecosystem Services leasing policy and the road access, the permit policy, which is 300007 and 09. These are the road access permit is a non-standard one, so it falls outside the leasing decisions that you've given to staff. And the Ecosystem Services production lease requires board action. It also will involve approval of a permanent conservation easement. I also have, I believe, the lessee may be attending online. Grace Stevens representing Sandy Creek Partners Conservation, and Stephen Decker with Rocky Mountain Mitigation, who's involved with the project, was also planning to attend. Neither one of them were planning to make a presentation, but I am expecting, Stephen just arrived. They are available to answer questions if necessary. So this project staff expects that it will generate $4 million from wetland restoration. This is a perfect example of Ecosystem Services Program's ability to monetize ecosystem services on certain properties that meet certain conditions, and also provide long-term preservation, in this case through a conservation easement, but long-term stewardship. All the photographs in this presentation are on the Crystal Lakes Stewardship Trust property, where this project will take place. The Crystal Lakes property is one of just a handful of properties we have in Lake County, Colorado. It's located in Central Lake County. And the regional location is, it's this small 3/4 of a section located about, I think it's 10 miles south of Leadville. We only have 2 other properties in Lake County. Our recently acquired, I just wanted to. Fort Ranch. Fort Ranch, sorry, or Fort Creek, and then our Box Canyon property. This is a little bit more of a close-up that shows what parts of that 3/4 section will be affected by the ecosystem services lease and the access permit. This triangular area is the area. It's outlined in kind of 2 separate green sections, and I'll explain why it's in 2 pieces. But this is located on that lower floodplain area. This upper bench, you'll see some other photographs of it in later photographs, also like in later slides, is kind of a sage step shrubland that will not be included in the project. And then the road access permits, we have this, the ecosystem services lease area will have access, will require access from both the east and the west. These are both available from the west through County Road 10. And the road access permit will get them from the public access across their non-lease area through 2 separate existing 2-track roads onto their lease area. This will be effective only during the active lease period. And because during the planning lease, we normally lease the entire section. And when the lessee is ready to come to a production lease, we narrow down the area just to the area that will involve the bank and the conservation easement. And because they don't have public access to those areas, we grant this non-standard road access permit. And traditionally, we don't charge for that because it's provided as a means to develop the mitigation bank. From the west, there's an access road through the BLM land. And the lessee is also exploring securing public access directly to US 24 through this very small area on the northeast part of the property. The reason this is divided into 2 conservation easements is that an old, somewhat abandoned railroad I shouldn't say that it's abandoned. It has not been legally abandoned. The Denver and Rio Grande Railroad goes through this property. I'll show you a photograph that later. And then the Arkansas River travels southward through the property. The area on the west side of the railroad will not be under any construction. It'll just mostly be a preservation bank of existing wetlands. There will be some additional modifications and treatment of weeds and so forth, but we won't have any construction on this side. Most of that activity will take place on the eastern part of the property. Here is a map of the project. Again, this shows the different types of wetland enhancement and restoration that will occur. This chart, it lifts out, and I think you might be able to see this also. This has been included in your packet as well, and shows the different types of credits that will be generated. Again, on the west side of the railroad right-of-way, most of this will be preservation activities. This is where the 81-acre fen is located. And in general, the wetlands located on this side, on the west side, are in very good condition, in some cases pristine. The wetlands on the east side of the property are in less pristine condition. And that's where most of the credits will be generated, is on the east side of the property.
And is that the site of a lot of the grazing?
Yes, actually, both sides were grazed. The Moyer Ranch has been leasing the area on the east side of the bank project area, and Bryce Lewis was a lessee on the west side. He actually relinquished his lease about 1.5 years ago. Any questions before I move on? Okay. The project highlights. The project size will be about 230 acres. That does not include the railroad right-of-way. That'll be legally excluded from the conservation easement and from this project. The approximately 195 acres will be restored of wetlands and the fens, either restored or protected. This property is in the Stewardship Trust. It's one of the first that came in the very first round of designations in 1998. And it interestingly has, in the different categories of why lands can be in the Stewardship Trust, this one ticks every one. It even, I didn't put rare plants up here, but it even has some rare plants of the blue-eyed grass. There'll be no change to the recreation leases on the property. There are two. One is a private recreational lease for guided fishing, and I don't know if it involves hunting as well, but certainly fishing through a company that's based in Leadville, and the Hunting and Fishing Access Program. It will involve 89 or almost 90 wetland credits and 16.3 fen credits. Those are unusual and command a higher price in the marketplace. And the estimated state land board revenue over the length of the project is about $4.1 million. That's just the state land board share.
Quick clarifying question, just for personal curiosity. Do you need to be destroying a fen to be able to utilize a fen credit?
Yes.
You did that too.
Yeah, so for a project, and I mentioned previously that the rural reservoir is the planned Fox Canyon Reservoir will affect some fens. Will cover some fens. This is the Crystal Lakes property looking north toward Leadville. Leadville is located around this bend of this higher bluff. I will just say for a moment that this lower floodplain of the Arkansas River Valley was created through a series of glacial washout burst, tremendous flooding that happened. The first one, they think 640,000 years ago. A few have happened since that time, but we basically have the floodplain located, some 40 or 50 feet below this bluff. This picture was taken from our property looking northward. So I'm standing up above this bluff. It's about 30 or 40 feet, like above the floodplain. And then the Arkansas River is kind of braided through this valley. Our property ends before the valley rises on the other side, and US 24 is at the base of this bluff on the eastern side. Before I leave this, I want to point out this small flat area at the foot of the bluff. This is an existing water ditch that's really not used. It's mostly vegetated in. This, however, this ditch holds water held by Aurora Water and Lake County, and it's the primary location where a new water pipeline right-of-way will probably come through. You'll be seeing that probably in the next 6 to 12 months as a separate right-of-way action. That consideration of that right-of-way was something that we learned about during the SCP's Conservation's early investigation into this site, and that's why this has been held up for so long, is discussions with Aurora Water.
And again, for clarification, you were suggesting it would be a pipeline?
Yes.
Buried underneath, okay.
Yes. Can I go back?
Yeah, use the left arrow. Here.
Go back to. Yeah, perfect. Yes, it will come probably down that flat area, or one of the options, and I don't want to get into too much detail now, but is to cut into the bank. That's an option. I will just say this site is critical, and I'll show you another map later, to the location of that pipeline. They really, Aurora Water will have a very hard time not using our property. Okay, this is from the same spot looking south, same situation. You have this area at the base of the foot where this water ditch is, and then the similar kind of landscape looking south as well. You can see the difference between this highly green and vegetated floodplain and the drier lands up on top of the bluff. Just a few more photographs that give you a feel for the site before I talk more about the lease details. Here are some of the wetlands that have been impacted just by heavy livestock use. It's common to see this hummocking, where the soft peat is pushed down and you end up with lots of hummocks, and rare plants are sometimes stranded on the top of some of these things. Streamback erosion. This is a picture from the east side of the property too. You can see not just this erosion here coming down into the creek, but how these farms are being eroded here and depositing soil, and just creating an unstable an interaction between the water and the floodplain. These are things that would be addressed under the mitigation bank project. There is an 81-acre fen located on the property on the kind of the northwest side of the floodplain. And then here's a photograph of the Denver and Rio Grande Railroad right of way. This is in fairly good condition here. The railroad as a whole is not usable today. There's areas just off of our property where there's track missing and so forth. But this is the railroad that you may have heard about. This is the railroad line where I don't know the name of the company, but looking to move oil and gas from Utah through Colorado out to Arkansas. So this is that very line that would come down through our property. We do not actually have a right of way with this railroad. We have a, so we don't have that papered, as it will. Existing lessees. The first of these, I just want to review these. Because this is in the stewardship trust, and also so we notify of new uses. We did that back when the ecosystem services planning lease occurred. We also do it as part of the ecosystem services leasing policy, that we notify all active lessees of this proposed action and give them an opportunity to comment. Some of those comments are included as part of the full packet. The Moyer Ranch has that grazing lease on the east side of the railroad. They also have water rights associated with the ditch. We'll need to preserve access to that, to those water rights. And also recently said they improved the fence and need to compensate them for that if that's included in the mitigation bank area. I put Moyer Ranch in red because that's the only lease right now that will be negatively impacted by the ecosystem services production lease. CPW has a hunting and fishing access program lease that's expected to continue, as is the private recreation lease held by Alpine Ski and Sport. CPW provided comments, and that's provided as an attachment and exhibit in your board packet. Alpine Ski and Sport did not provide any comments back to the board. The city of Aurora also has a water ditch right-of-way. The board approved that about 2 or 3 years ago. That's located in the center of the project. That won't be impacted by the property. There's a transmission line along the south end of the property that won't be affected. And then SCP Conservation holds the planning piece. That will be, as if subject to board approval, transitioning to its production lease. The Aurora water right-of-way, I've mentioned this before. This is a map provided by Aurora Water. This is the location of the Fox Canyon proposed new reservoir. Our property on this map is shown in purple. So we have property right here. We've been in discussion and have been leasing some of that land, or I'm not sure if there's a transaction, for the head wall of this reservoir, and then our Box Elder Creek. In order to provide the water from the Arkansas River down to that new proposed reservoir, for long-term costs and sustainability, Aurora Water is wanting to have a gravity flow pipeline. In order for that to happen and have it a completely gravity flow, they need to collect the water north of our property. And so it's very difficult for them to not use our property and bypass it. If they were to collect their water all the way down here in Aurora Water, they'd have to have a pump station, would be very expensive over time. So they're incentivized to, move through our property. Initially, their initial proposal was to go right through that pristine wetland. Now they're moving back against the basic bluff. We've been in discussion with Aurora Water for that proposed pipeline for about 3 years. They're proposing that this would cross the property to provide this water to the proposed new Box Canyon reservoir. And our recent discussions, and they've just recently completed engineering studies looking at 4 different alternatives, will be definitely moved out of that pristine wetland, and then we'll be meeting with them in the next month or 2.
Will that be underground?
Yes, it will be. I'm trying to think of all the different places it would be. Of the 4 alternatives, I think it would all be underground. So the details, the terms of the ecosystem services lease and the road access permit is, it would be a $5,000 annual ground rent
for starting in year 1 with a 3.5% rate escalation every year thereafter. State land board for the first time would begin getting 25% of the share of the gross credit sales. Previously, we've had 20%. The advanced minimum distribution. This is a concept that's been borrowed from mineral royalty, that in years where there are no credit sales, we would still get some advanced minimum distribution up to a point that staff set at $100,000. This would recoup some, the cost, our financial contribution. That would start at $25,000 a year, starting in year 4. That's only if we had not yet already received this $100,000 by year 4. I will say on all of our other leases, we have not had to ever been given the advanced minimum distribution because we've been able to get credit sales. This is one way that we've minimized our risk in these mitigation bank projects. There'd be a permanent conservation easement on the 230-acre mitigation bank site. This would not be put in place until the time the Army Corps actually approved the project. So we're looking at a time period of 12 months at the earliest, maybe 18 months to 24 months. And again, it wouldn't go on until we actually know the project is viable. And actually that placement of the first, placing the ecosystem, the conservation easement triggers the first sale, the first release of the first, I think 10% of credits. And the ecosystem services lease would be a primary lease term of 15 years. That's standard in our ecosystem services lease policy. And staff is recommending a 15-year road access permit to coincide with the term of the primary of the ecosystem services lease. Any questions about this?
Colorado Open Lands, I think you noted, is going to hold the easement and monitor and be responsible for that. Right.
This project, the conservation easement and the mitigation bank project, also comes with a permanent long-term endowment fund that will hold the principal and then spin off revenue every year to help manage and take care of the site. Once the bank closes, that transfer the responsibility for the management of that site will then come back to the state board, and we'll be able to use that funding to manage the site.
I have a question.
Sure.
I was curious that it's managed by Indian River Community Foundation. Do we know what kind of returns we're getting on that endowment and why it happens to be managed there?
Yes, that really has been at the discretion of the mitigation bank sponsors. So these companies have numerous other bank projects, and they tend to have a standard partner that they work with. Sandy Creek Partners, or SCP Conservation, is based out of Florida. They have quite a few other endowment funds that are based there. So we've allowed that. We have Colorado Open Lands has held one of our endowment funds, but they've communicated that they're not business of managing endowment funds, that primarily versus holding and monitoring conservation easements. In fact, of our 4 mitigation projects that we have that are generating credit sales, they have them in 3 different organizations, and they're usually nonprofit so that they don't have to pay taxes. So, any other questions?
And Mindy, if I can jump in.
Sure.
On the fen restoration, is it acre to acre in terms of offsets?
It is, no, it is not. In fact, I might have skipped over the slide. In fact, I did. Yes, I do. There's a slide that shows objectives. Keep going. There. Oh, I'm sorry. I hit it. I'm sorry. I was going to just explain it. If you go to the slide, I think it's one back further. Sorry. They're right there. This chart shows that not every acre is treated the same with being restored. This site will do restoration, but there's actually reestablishment where we're rebuilding the wetland, and so we're doing a lot of enhancement versus Stephen, I'm going to bring you up here to.
Sure, would love to.
Yeah. Can you introduce yourself for the record? Here, sit down and just.
Perfect.
Yeah.
Stephen Decker, Rocky Mountain Mitigation.
Who's in partnership with SCP Conservation, our lessee.
That's correct. I'm a Colorado company that does wetland mitigation banking So I partner with SCP Conservation to identify and get the projects permitted and work through the long, sometimes hard regulatory process. And then to answer the question on the phone, from this phase to working with the regulatory agencies, we propose certain credit types and certain credit ratios. So currently what we have is there's roughly 81 acres of fen. And then what we've proposed is some other areas of fen restoration. And so it's hard to say today what we'll get exactly for credits, but those credits will likely not be one-to-one for preservation of the fens.
Here you have five acres to one.
Correct. Yeah. So in this proposal that we're looking at, it's a 5-to-1 ratio. Some of the green areas on that map are 1-to-1. So some of the areas potentially that could be fen restoration could be potentially 1-to-1. So it's a little nuanced here. So to answer the question, most of it's 5-to-1, some of it's 1-to-1.
Right. And there are
in
some
which
that-
direction? Which direction is that 5-to-1? Is that 5 acres credit to 1 acre restoration, or the other way around?
Yeah, I apologize. So it's 5 acres of 5 acres of preservation to 1 credit. And then
Okay.
Yeah.
Okay. And then who decides at the end whether they've been properly restored? Actually, 2 questions. That and what's the process of restoring a fen in 2 seconds or less?
Yeah, no, and I'll keep it short here, but just wanted to address this other question from earlier, and I can capture it here, which is the Army Corps of Engineers defines fens as a special aquatic resource, which means they're hard to replace. So they really look for areas like this that are in good condition or great condition that could use some improvements. And then they really like those. So in this case, we think that there's a high potential that the Corps will give us either 5 acres for 1 credit or even greater for the preservation of a special aquatic site or restoration of a special aquatic site. And then there is a higher level question here, which is, can a fen be restored? There have been a couple projects, at least in Colorado, where they have taken the peat, and that's the definition of a fen here, which is layers and layers of peat over hundreds of years, thousands of years that pile up that are not broken down. And so a fen restoration, at least the couple projects in Colorado, what they've done is they've taken peat and placed it back into some of these areas that historically were mined. People use back before I was alive, people use peat to burn for fuel, and so that's it's just a mining. So if they can find some peat to place it back in that area, then maybe they've restored it, at least placed the areas where the flow can kind of come back naturally. There are people that argue that you can't restore a fen because a fen is 1,000 years of layers of natural buildup. And so I don't think we need to debate that. The Corps might not need to debate that, but it might be how we in the end label that in our mitigation banking instrument, whether it's a fen restoration or a wetland restoration or some kind of fen enhancement. And so the regulatory agencies, they'll help us define those definitions as we kind of move along in the process.
Thank you.
So I have a question. Did you say you're actually going to destroy 1 fen on the property?
No, great. So I think your question earlier was, so this is a Army Corps US EPA offset program. So what we're providing, we'd be providing fen credits. So that would potentially allow somebody else somewhere else who has to impact a fen, a DOT, typically they're going to do a big roadway. There happens to be a fen that they have to cross. They have to go across it. I think Mount Evans or Mount Blue Sky is a good example. They have to redo their road up there. If you guys have ever traveled that bumpy road, that's a road that needs to be replaced. And that's a fen that goes through there. So that's an example of they'll have to replace those credits somewhere.
Other questions? Is there any public comment on this topic?
If you're listening along online and wanted to make a comment on this item, raise your hand. No hands raised.
Right, then commissioners, if you're ready, I'd entertain a motion on this matter.
Is there another question? You approve the lease 118.
Board order, do you have the board order?
I do.
All right.
And it is in your packet as well. The
Yes.
sixth.
Madam Chair, I'm prepared to do a motion. Thank you. I move the board approve Ecosystems Services Lease ES 118010 and road access permit RAP 118084 as contained as a board order in the packet of March 12th.
Second.
Second by Commissioner Pribble. Commissioner Harvey, how would you vote?
Could I make one comment or is it too late for the discussion? I support this, but it would be interesting, maybe a little bit of staff work to find out, what Stephen just said about the viability of restoring a fen. It'd be nice to know a little more about the real viability in the future. But I would support this motion.
Thank you, Commissioner Harvey.
Mhm.
So you support, so that's a yes?
Yes, that's a yes.
Okay, Commissioner Pribble,
Aye.
Commissioner Heath.
Aye.
Commissioner Scanlon.
Yes.
And the chair votes yes, carries 5-0.
I'm wondering, is it possible to visit this when we go to Leadville in September?
We would be able to, wouldn't we?
That's right.
Nobody seemed to.
Fan.
Yeah, that's right.
I
have read my own.
Clock and the P.
Exactly.
Thank you.
Okay, before, we're about ready to take a short break. And I had overlooked the fact that Director Rosemarino has a comment to make.
Thank you, Sheriff Robe, Nicole Rosemarino, Director of the State Land Board, for the record. I have two comments. One is, you can come in and have a seat, sorry, that Commissioner Harvey yesterday asked whether there were any surprises from our strategic planning consultants, interviews and synthesis of themes and insights they were hearing. And there were two really striking results. One was really broad support for advancing stewardship. Another was very broad support for diversifying revenue. But the follow-up question to each was, what would this look like? And I think what you just approved is exactly what it would look like, where we have just profound financial potential as well as significant advances in stewardship. I'd also mention that we have an RFP out for asset allocation modeling, so we can really make informed decisions about these trade-offs. And so I just want to compliment especially Mindy, and I know Assistant Director Elliot Hoyt worked on this project. This is really, I think, very compelling in how we're meeting our fiduciary duties in both revenue generation as well as stewardship. So thank you for supporting staff recommendation. I thought that would be helpful for you to hear. My second comment is it might be also helpful to hear a little more, even though you voted, about why you voted in the way you did.
Yes, we need to keep making the record.
On this particular one?
On all of them. Right?
Yes, but right now it'd be helpful for you to articulate why you supported the
Curious,
staff's
is this a legal requirement? that you're suggesting? Seems to me the discussion informs the
Yeah.
vote. And there was pretty ample discussion.
I heard ample clarifying questions.
Yeah, it's Ed suggested we do this, but I have to acknowledge it's kind of new.
And it's also nuanced because I didn't say, let's have discussion because everyone was engaged.
And having discussion.
But questions are different than discussion, and discussion is where we make our.
Yeah, in fairness to us, we have not had to do that before. We've had discussion and then we vote, and it's always been assumed the discussion is clear why people are voting.
Yeah.
So,
I'll say from a legal perspective, it is helpful to have that record of the articulation of the reasons, and that kind of happens as part of the discussion in some cases, and in others, it's helpful to be.
Can the counselor provide some clarity around how much discussion is necessary or desirable as compared to just superfluous and waste of time?
Sufficient discussion to, provide the reasons for the decision that's being made. And so that's going to look different for every matter.
So it's council suggesting every commissioner has got to explain every specific rationale for every vote every time?
No,
Is
and
that the position of counselor?
No, it is not necessarily, but and sometimes that'll be summarized by the chair. It's going to depend on the nature of
That's
the
what
discussion.
I should do more, better job of that. Just, the top 3 reasons that I'm putting forward, and if anybody disagrees.
is it fine to just say we are in support of staff's recommendation?
You got pretty full,
Yeah.
we have board packets that range from 200 to 700 pages
900.
of material.
But I think maybe this comes out of the whole Princeton thing where council is merely wants just a few words backing up how we made our decision. So if they ever have to defend it, they just have a few words from the board as to why they made their decision, so it doesn't sound arbitrary.
Yeah, and right, if it's not, if I'll try and do a better job of trying to articulate what appear to be the primary points in the rationale, and then others can chime in. And yes, and Elliot, I'm sorry.
Yeah, thank you. Assistant Director Elliot Hoyt. To that point, I think that's exactly what I've heard council say in the past, is that when it's their turn to defend us and defend you on decisions that are made, that in between the motion and the second and the vote, it's very helpful for at least a few, 1 or 2, maybe all, to say, I was really compelled by the packet that I read, or the presentation that was given, or the answer to the question that, Commissioner X gave, just so that it's really clear in the record why you're making the vote you are. It doesn't need to be, pontificating on endlessly, but I've heard that it helps to, in that moment, say, I'm going to vote in this way because of this. And it can be as simple as, staff's recommendation was very sound. I agree with what they recommend. So.
Okay, so everyone,
We'll
I'm voting because, or I'm voting.
Yeah.
Okay.
We'll get into the habit.
Well, yes.
Is a new effort.
We're gonna have to go squirt.
It's as.
All right. Well, I think it's time for a short break, if that would work for the other commissioners. Yes.
Yes.
All right.
Sounds good.
All right, let's say at the stroke of 11.
We are back live.
Hello and welcome back to the March meeting of the Colorado State Board of Land Commissioners. And the next item on our list is, yes, I seem to have lost my agenda. Is the Chancellor Ranch.
That's a great photo.
That is
a great photo.
Morning.
Good morning.
I'm happy to be here this morning with you guys. We're presenting a
an I&D request for some funds to purchase and install and get some new improvements for the chancellor today.
Yeah. Can you say name?
Oh, yes. I'm Eric Van Dyke, sorry, Southeast District Manager out of the Lamar office. And I would like to know, Jackson Donnell's with me. He's a Southern Resource Specialist here in case there's questions. And Mr. Wooten and Mr. Carney are also in our, they're on the Zoom meeting here listening in if there's questions for them as well. So the Chancellor Ranch is in the very southeast corner of Colorado. It's 51,500 acres. Few of you have been there, I know. The State Land Board owns all the improvements on the ranch. There's new houses, headquarters house. There's a recreation house. There's wells, storage tanks, water lines. Everything's completely owned by the land board. This is the headquarters house that was built in 2018. And this is the hunting lodge. I know you three ladies have all been there, so. This is the well that was the new well that I didn't have the right picture. It's the old well is about 15 feet away from that new pipe that's sticking out of the ground. It replaced the casing failed, and so they brought a truck in and drilled into the same aquifer right next to the Pearly well. But I put this in here as it's being pretty new, and the Pearly well is very important as it's one of the, it's probably the main source of water for the Chancellor Ranch. It's not the only source. There are other sources as well, but this one provides the lion's share of the water and is plumbed all the storage tanks and stuff like that. These are the frac tanks, as we call them, the new storage tanks that were installed that store each one of the. We're not talking about the round old tank on the left, but or on my left, the two frac tank looking things. They store 20,000 gallons of water each. And what we're requesting is to build a new set of pins, to tear out the old set of pins and build a new set of pins that would be, this is the old set of pins for those of you that haven't been there or don't remember. They're very dilapidated and not in very good repair, and they're still usable. They still do use them, but they're not functioning as they should. Anyway, to remove all those old pins and build something with an alley, sorting alleys, and an alleyway to brand and loadouts for the semi trucks and things like that. This estimated cost is about $100,000. And they are going to change they're going to somewhat change the direction of the pins. They'll be in the same place. So currently now the trucks, they have to drive out onto the prairie and go clear north of the pins and back up and then turn back out to get south. And it's obviously the traffic is hard on that few acres of ground. They're going to have the alleyways where they're already pointing south, so the trucks can turn around in the yard and back right in and be quite a bit less impact on the grass there. We're also requesting another smaller set of pins to manage some of the parts of the herd, and this is in the Dresden pasture, which I'll show you here. the Dresden pasture where they're wanting to, this second set of pins is about where these three come together right here. So these will be used by, to manage this east side, to gather bulls and to brand, calves in the spring and, possibly wean some years, you wean some cattle in the fall off of the main, set of pins would be here at the kind of the headquarters is where this orange dot is, just for your reference. Okay.
Remind me again, how many head of cattle do you have there?
About 600, give or take, depending on the year and the condition of the weather, the drought, and how much water we have. And then, so that's 50,000 for the smaller set of pins in the Dresden pasture. We're also requesting 75,000 to drill and plumb a new well to have a backup to Pearly number 1 and to help maybe take some pressure off of Pearly. I keep going the wrong way. And that well will be kind of up here on this. It's not listed on here, but it's Doss Canyon right here is kind of where they're wanting to put the new well. And for information, Pearly well is clear down here in this. I don't quite see Pearly Canyon, but I think this is Pearly Canyon right here. So that probably this red mark right here is where the Pearly well is. Also we're wanting to put in a 20,000 gallon storage tank that would go on the pipeline road. If you ladies remember when we went to the west side to the Purgatory, they go up that little hill and through an old wire gate. That's kind of the high spot there. The Shequock Cattle Company is thinking to put a storage tank for water here as well. There's three new stock tanks that are not holding water anymore that need replaced. There'll be this storage tank and the stock tanks and the well is all figured in there and in the reworking of some other solar wells, taking the windmills out and putting in solar pumps. And there's a lot of pipe that's been included that'll be ripped under the ground to connect the water all together so that the Pearly well and the new well and the house well will all be plumbed together to alleviate just one of them having to do the majority of the work.
Man, did you just take the windmill out?
No,
I mean,
no, just they have to unhook it from the.
yeah, but you
Yeah.
know, it gives it a nice character for that.
Oh,
ranch.
sure, yeah. No, I don't think there's any. We haven't talked about it, but there's no intent in removing any of the aesthetic things from it, just making it more functional, more usable. And then also we have in 2018 when both houses were built. At the time they were budgeted for appliances that are inside the homes. So all the appliances were purchased by the Carney and the Wooten family. And now that one house is changing hands to KB Outdoors, we're requesting that we purchase the existing appliances from the Wootens and the Carneys, so that we maintain that we own all of the improvements on the property. we also figured in a 15% contingency cost on in case projects go a little over budget or pipe gets a little bit more expensive or less expensive, for a total request of $358,800. One thing to kind of got out of order here. One thing to that I want to note is that this 358,000 from the IND request would be the max that we would use. The Wootens and Carneys are currently enrolled in with NRCS and working on getting equip funds, which could be anywhere from on water and storage development and pumps and wells. Could be 50, it could be 30%, 50%, could go up to 80%, I think. So this number could be significantly less too, and that would be not used somewhere else. It would just be returned to the IND fund. Based on the information provided at the March 12th board meeting, March 12th, 2026 board meeting, staff recommends that the board approve the use of $358,800 of investment and development funds to complete the property improvements on the Chancellor Ranch, Los Animas County. The IND fund has sufficient capacity to support this request. Any other questions or discussion?
I like how you've left us with the stimulating picture of our asset. Yes.
I have a question, Madam Chair, but it's not related to the request.
Okay.
Please go ahead.
I'm reading the materials about the tour a couple of years ago, or last spring, before I was on the board.
Right.
There's a reference to beetle treatment of the tamarask invasion along the creek. What's the status of that? How is it working or not working to control tamarask?
Steve, if you could get on and answer that question. I'm not experienced enough to give you a good answer.
Promoting Steve to panelist, and it'll take 10 to 15 seconds.
Not on that, you can answer that separately later. I don't want to get us off track here. I was just curious.
It's coming.
Eric, can you remind us how much that ranch generates every year in income on the lease? Or anyone?
It's in the board packet. I don't have
okay,
that.
I probably missed it. Okay.
Thank you. The new lease that will begin in April of this year is the agriculture grazing lease is $259,500 annually.
Okay. And on these new sorry, go ahead.
It also has a rec lease on it that is at $115,469 annually.
Okay. And on these new pens, are you just going to repeat the pattern of the old pens, or are they going to be carefully designed, with Temple Grandin's ideas, stuff like that, new squeeze sheet, whatnot?
Absolutely, yes. The pen that's there currently is actually, I believe, was actually more of an arena that they used to rodeo and enjoy that part of ranching as much as the working of the cattle. So the pens will be significantly smaller. It won't be that very large area, and yeah, the designs I believe also are in the board packet.
Oh,
but they are.
I
don't think we didn't put those in it. Okay. Yeah, the designs are up to current kind of I guess Steve can kind of answer to that too, is how they came up with the design. So
Steve's on. Steve, you're welcome to say something if you want.
Yes, thank you, Eric. Thank you, board, for the opportunity. First, the Tamarisk. We were running a pilot program some 15, 20 years ago with the Nature Conservancy and Colorado Great Outdoors for funding, and treated the entire Shiquak region into the purgatory. And then we at Beatty Canyon went ahead and continued to work trying to use the Tamarisk beetles. And what we found is in the eastern part of the Colorado, in the zones on the Arkansas, the Purgatory, Huerfano, Pishapah, we have a predator in the form of an ant that feeds off the larvae of the Tamarisk beetles that are available to us today. There were 2 other species of Tamarisk beetles that were available, but there was a lawsuit brought because of willowtail flycatcher that was found to be also utilizing Tamarisk as a nesting site. So those 2 other species that might have been not affected by a predator were removed from the list that we could use. So at this time, we're not using any biological control. You'll get 1 or 2 years of response specifically during a drought when the insects are not populating. And then when you come out of the drought, you get moisture, insects come back. You'll see those ants all over the Tamarisk, and they'll just completely eradicate your larvae as they hatch, who are the ones that actually do the feeding on the leaves of the Tamarisk. So for us at home, we used mechanical means to treat it, used an excavator to lift the plants out at the ground level. And then when possible, try to burn their slash piles. But that's a slow process due to the fire propensity in Southeast Colorado. But it does change it. It's a very expensive process to get in there. And in the Purgatory region of Shiquak with no roads and very difficult access, it would be even tougher to mechanically remove Tamarisk. Possibly the one viable method to treat it is with helicopters. And they've got pilots that have equipment on their helicopters that are so specific that they can turn on one nozzle and spray a tree with one nozzle while protecting a cottonwood tree or a grove of willows that are already there. So, but again, we're talking a very high cost over the total acreage in the Purgatory. We've seen a few spots in the Shiquak that have some treatment, and our plan is to use Garland or another water riparian zone safe herbicide and hit those with spray so that we don't see a regeneration in the Shiquak. It's pretty remarkable the lack of Tamarisk that exists in the Shiquak yet today after that initial pilot project. About the pins. Our pins are designed to get away from what we're having trouble with in these pins today. Number one, that there's an animal welfare problem with the pins. There's all kinds of nails and studs and wire and things that are detrimental to cattle as they're going through there, but they're also not designed to flow cattle well. So there's an aspect of worker safety in there, whether you're horseback or afoot. There's traps throughout the whole area where an individual can get trapped by cattle. And so our pins are designed that way, and the people that we've asked to provide us with bids are fully aware. We gave them a general idea of how we want the flow to go and what materials we want to use for safety and animal welfare, and longevity that's another factor. We want 30 to 40 years out of a set of pins with just general maintenance and things like that. So for the moment, I'll pause. I did have some more comments, but I'll let you guys keep working on your discussion.
Thank you for that, Steve. Good to see you. Questions? Any commissioners have any other questions on this? I have a question that's not related to it, and I don't know if Eric or Steve can answer, but for the first time ever, I noticed that there was an in-holding in the middle of the ranch. And I wondered who's our in-holder?
I don't know off the top of my head.
Steve, do you know that one little square in the middle?
Madam Chair, I do understand that there is a private inholding in there, and with William and even as far back as Greg Oquist, we had petitioned them to contact them and see if they would be willing sellers to close up that small private inholding in there. And we didn't follow up and ask, so it's possible that when they were asked, they wanted to retain their inholding. There is also another perimeter holding on the very northeast corner where State Land Board adjoins Bobby Hill and the Purgatory. There's a small inholding in that area too. Fortunately, it sits on the boundary and it doesn't impact the interior portion of it, but it does have some access probabilities to it as they come and go through the State Land Board's property.
Thanks. That was just a matter of curiosity, actually. I had never noticed that before.
I vaguely remember we approached them and they were not interested. They may even be out of state. I can't totally recall, but I think we tried.
Yeah. And
It didn't go
obviously
very
they're not having active use of it that's posing a problem at the moment anyway.
It's not fenced out separate or.
Yeah. Okay.
Madam
All right.
Chair,
Yes?
Chillicothe Cattle Company does pay a de minimis lease on it. Just to be fair with them as in holders to not be, since it's not fenced and not separated from the use in the pastures, we do pay a de minimis lease annually to them.
Oh, that's actually good to know. For some reason, I thought it might have this little fence around it. So good to know that it's not impairing your operations, and that sounds like a great strategy. Shall we see if there's any public comment on this matter?
Yeah, folks listening along online, if you're here to comment on this item, please use the raise hand button. No hands raised.
Commissioners, I would entertain a motion on this.
I'll make a motion. I'll make a motion that the board approves the use of $358,800 of investment and development funds to complete the improvements on Chancellor Ranch in Los Animas County, as described in improving the pens, the wells, and everything else that the ranch has petitioned for.
Thank you, Commissioner Harvey. Second from Commissioner Pribble. Now, thoughts or comments from any of the commissioners on this matter?
Not a commissioner. Can I ask a technical question?
Please.
In the packet materials, it's not entirely clear if we think the projects involved are going to take more than 2 years to accomplish. Do we have a time frame that we want to set? The reason I ask is the board may not know this, but in the background, our board orders hold a default authority timeline of 2 years. And so if we know it's definitely more than 2 years, I would ask that the board permit the authority for some period of time that's longer than that.
The plan as I understand it, and Steve, you can jump on here if I'm incorrect, but the plan as I understand it is to finish what we have here today in 1 year. They're ready to, they were ready to get started 2 months ago. And also would like to add that Chillicothe is, the cattle company has offered to be the general on all the projects, the general contractor, so they will be the one funding everything, and will reimburse them for that. So
great.
So my question doesn't require anything from the board.
Okay. I think these are all needed priorities and would support the request. I know the pens looked old when they were old 2 years ago, so I think these are the right priorities.
Yeah.
I think these are right priorities, and I also, as laid out in the staff memo, I also appreciate that our lessees are contributing some sweat equity and labor and effort. So appreciate that from you, and it's, a partnership effort that way. So I really appreciate that aspect of it.
and the development of the water not taking anything away from the pins, but the development of the water is going to make it a lot easier to manage the grass on it. It's going to entertain more livestock or more wildlife. I mean, it's good all the way around, because with that, there's 3 or 4 or 5 miles across there that if it doesn't rain, there's no pond water, there is no water. So.
Right. No, the water sounds really important. All right, then may we have a vote on this? Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Yes.
The chair votes yes, motion carries 5-0.
Looks
Thank
like
you, Eric.
Steve has his hand up.
Oh, Steve? Yes?
Thank you, Madam Chair. But I indicated I had some other comments before you voted. We had visited as Shiquat Cattle Company, and where there was no fencing included in this phase of improvement on the ranch, we had suggested that in lieu of the $20,000 of the appliances, that we apply that $20,000 so that we can hire additional workers to go through the existing fences and get them up to at least honest cow tight structure, including there's probably going to have to be some new corners, some new gate braces, but use existing wire and posts and just do general maintenance and repair as is for this time being. So we wondered if the board would be comfortable with that as opposed to spending money on appliances to spend it on something that maintains your infrastructure.
Counselor, is this something we could delegate to staff, or I guess since it's a very specific board motion, we maybe need to
Yeah, it's
redo it.
gonna be changing to that extent. We're gonna
Okay.
need a new motion.
So do we have to replace it, or can we just do a new motion that includes in place of that motion?
The new motion would be sufficient as long as you make it clear what
we're doing.
We're amending the previous motion.
Steve, I'm sorry, I didn't realize you had a comment affecting the actual motion.
Thank you, ma'am.
I can take a shot at this, that we would like to amend the previous motion to replace the I&D request that was approving specifically the appliances to be used in accordance to the comments by Steve Wooten for what they need in terms of fencing. That suffice?
Yes.
Okay.
So we have a motion on the table to revise the prior motion as stated by Commissioner Scanlon. Do we have a second?
Second.
I have a question.
Okay, we have a second, and Director Rosemarino?
Yes, Director Rosmarino, just to clarify, would that mean that the appliances would then be owned by the State Land Board?
Yes, I believe so.
Is that what you're intending, Steve?
Yes, ma'am.
Your comment?
Yeah.
Thanks, Eric.
We'll just take them. Yeah.
They'll give the appliances to the land board if the land board would.
Yeah.
Take the same amount of money and
Allow
put it
them
into
to use that.
rebuilding
Yeah.
the existing fence.
So that's a nice contribution.
Yes.
Thank you for the clarification,
Yeah.
Director.
No, helpful.
So we have a motion to revise the prior motion as stated. We have a second. Any further discussion?
I want to respect the chair and the director's new advice, and I desperately wanted that microwave.
Shoot.
Oh, you can't win them all, Joe. I'm sorry. All right, then, notwithstanding the microwave, Commissioner Harvey, how do you vote?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Yes.
And the chair votes yes. Motion carries 5-0. And thank you very much, Steve, and I think Pat might be on there too. Really appreciate your efforts on the land there.
Nice to see you.
You too. Thank you.
Thank you. On behalf of Tyler, thank you as well.
Yes.
Elliot Hoyt, Assistant Director. I'd also like just to let the board know that this was focused on the on the agriculture lease, that, you know, it's turning over. Shiquak is continuing on as ag lessee. We will have a new recreation lessee. We've separated out those improvements and those discussions, so please expect in the future that you know, our recreation program manager will come to you and we together with KB Outdoors and discuss whether there are improvements that might be necessary for the recreation program.
Great, thank you for confirming that. All right. Getting myself lost.
Good afternoon, Commissioners. Elliot Hoyt, Assistant Director of Sustainability and Working Lands. I do not have a slideshow for you for this, which is the policy review for military lands. If you want to flip to tab 10 in your board packet, you will see that, as you may remember with policies, we have 3 exhibits. The first exhibit is the current version. The second exhibit is the red line, and the third exhibit is the proposed amendments to it. So there's not a lot of change here. I'll just say that this policy is very important to the land board. It was created, I think 2021 is when it was first established, in part because of the certainly we have many lands, especially in the sort of Colorado Springs area, that are adjacent to military installations. And you are all well familiar with the work that we've been doing with our partners, the Nature Conservancy, Palmer Land Trust, you know, other entities in terms of the REPI program and the SOAR initiatives. Bless you. And so this in part has evolved out of those conversations and those needs to, you know, work very closely with Department of Defense on military installations that are critical to the nation's defense and to the economies of these communities. So there was an update in September of 2023 where there were a number of changes that were made because it was first written, and you use it for a little bit, you tweak it. There are effectively no changes other than a few copy editing changes since 2023, which I think is a great indication that, you know, we're doing a good job. We've got a good policy. It's working. I communicated with our liaison that we work with for military matters, and also we had somebody at the Air Force Academy review it to make sure that there wasn't anything that they wanted to change about it. They had no comments or changes beyond what we had. So I think we're in a good shape, and I'm happy and proud of that. I think that's great. I would like to make one further edit beyond what you have in the board packet, and council will help me with this, but in authority, which is the second section on the first page of it, in the second paragraph, there's a reference to Colorado revised statute, and it's incorrect there. The correct statute should be 36-1-123.5. So we need, with your permission, the recommendation will be to accept the changes as presented in your board package with that one additional amendment to correct statute in that section. Anything else that I should add? That covers it. So with that, the recommendation is to accept the changes as noted. And there is also, when you get to that point after public comment, there is a board order in your packet. It is much shorter and simpler than previous board orders you've seen today. Questions for me?
It's pretty straightforward. Let's see. So any questions?
Yes.
I was contacted when I came on the board by Nature Conservancy. They have a program. They showed me a map. I think it was called SOAR, SOAR.
Yes.
And a lot of the properties identified were in and around the Colorado Springs DOD holdings. Say a few words about SOAR, what that's all about.
Yes, absolutely. That is that was part of what I was saying. The origin of this agreement was we also, REPI was a term that we were using previously. TNC has created an acronym for a larger effort, which is SOAR, which is this effort to work to create buffers around military installations. So it's not that Department of Defense wants to own more land, but they do want to have buffers around the installations that they have, that they know that will not create influences on those installations that would be detrimental to their operations. So working together, so the State Land Board, TNC, Palmer Land Trust, TPL, Trust for Public Lands, a number of partners, local county officials and so forth, work together. And some of these transactions that you've seen, like the Bohart transaction and others that come before the board, are exactly that SOAR initiative, which is to use monies to purchase lands that are then put under certain kinds of easements to be sure that they're going to be used in particular ways, and then they're held by other entities, and the conservation easements or agricultural easements are managed by third parties. So we're very much in partnership with TNC and others on that effort, which is very important to us and to the communities. So thank you for that question.
We couldn't put a big enough buffer around Space Command.
Yeah, we don't go intergalactic with our methods.
All right, any further questions? Is there any public comment on this?
Folks listening along online, if you would like to make a comment on this item, please raise your hand. Hands raised, Commissioner.
Quick question before we entertain a motion. Chris, with the modification of the reference inside the policy, we need to address that in our board order.
So when you moved for the board order, I mean, just note on there that it's being made modification.
Okay.
As discussed.
Okay, as discussed.
Yeah.
All right. Great.
Statutory reference, or however you want.
Okay, that's it. All right, great. So then I'd entertain a motion from a commissioner on this. Motion, Madam?
I can do that. You got it. Go ahead,
Yeah,
Josie.
Madam Chair, I move that the board adopt the policy review military lands 200-010 as contained in the board order, with one additional amendment as presented through Elliot Hoyt, and the number, I'm sorry, I didn't get, but would like to capture that for the record.
Second.
Second, Commissioner Pribble. Commissioner Harvey, how do you vote?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Aye.
The chair votes yes, motion carries 5-0. Thank you, Assistant Director Hoyt. And
You'll just give him the number.
The correct state.
He gave me the number, so I know he has it.
Yeah, and
Sorry.
Elliot already stated it on the.
Yeah.
yes, okay, good. And I propose, commissioners, lunch is here. What do you think about grabbing lunch and then restart at noon do you want to have a working lunch? I'm indifferent. We can do a working lunch. We can do a social lunch. Any thoughts? Okay, well, with Mark in Zoom land, why don't we call it a working lunch and take till the top of the hour to collect ourselves and our lunch, and then we'll proceed again at noon. Does that sound okay? Yeah. Okay. So it's a month. Hello, everyone. Welcome back to the March 10th meeting of the Colorado State Board of Land Commissioners. Next up is our solar lease. Welcome, David.
Thank you, Commissioner. Can you guys hear me okay?
Yes.
Great, thank you. So good morning, actually good afternoon by 3 minutes, Commissioners. David Rodenberg, Right-of-Way and Tower Site Program Manager, former Renewable Energy Program Manager. This final action item is a recommendation from staff asking the board to approve a utility scale solar production lease with Highland Solar One LLC. This item is coming to the board for decision because all renewable energy production leases require board approval. So this utility scale solar production lease, if approved by the board, will not only meet the state land board's renewable energy goals, but it will also earn the school trust $2.46 million over the 27-year lease term. This project is located here in the northwestern part of Pueblo County. The project site, which you will see more clearly in a later slide, is about 22 miles northeast of Pueblo. So because it's been a few months since I brought a renewable energy production lease to the board, I wanted to briefly go over our renewable energy leasing process, which some of you guys have heard quite a few times. So the board has a three-part process when it comes to renewable energy leasing on state trust land. The first part, prior to issuing a lease, is the pre-application review, where staff goes through a detailed review of the request to determine whether the project meets the board's policy and is in the best interest of the trust. Each program manager reviews the proposed project and the related state trust land to assess how it may affect their particular program. This review also includes the district manager as well as the stewardship team led by Mindy Gottsigan. The second part is the planning lease, which allows the developer to demonstrate a certain amount of land control to plan and start to develop the project. The developer will engineer the site plans, obtain environmental studies, obtain a power purchase agreement with a utility or a specific end user, and will obtain the necessary local government approvals. Planning leases are generally issued by staff per the board's delegated authority and will start out with a 3-year term. Oftentimes those terms are extended. I shouldn't say it, well, in some cases, but I'd say probably 50% of the time they seem to need to get extended just because of the time needed to develop these projects. Keep in mind that by executing the planning lease, staff has determined that the project meets the board's policy and goals, and that staff supports the project in regard to what is in the best interest of the trust beneficiaries. And finally, the third part is the production lease, which provides the project developer with the right to construct and operate a renewable energy project on state trust land. All renewable energy production leases require board approval, where the board is essentially approving the terms of the lease that staff has negotiated. Production leases typically have a 20 to 40-year lease term, depending on what the negotiated power purchase agreement terms are. They usually sort of match up. This project has gone through the first two steps, the pre-application review and the issuance of the planning lease, which is why we are here today seeking approval of the production lease and the negotiated terms. So Highland Solar One LLC is a project company that is owned by NextEra Energy Resources. NextEra is one of the world's largest generator of wind and solar renewable energy, as well as a leader in battery storage. They have over 25 years of experience developing successful renewable energy projects. They currently have 33 gigawatts of wind and solar and 3 gigawatts of battery storage. So the board has developed a great relationship with NextEra, who has a significant number of leases on state trust land. They have 11 wind production leases, 1 solar production lease, 1 battery energy storage system production lease. And these production leases all generate about 441 megawatts of electrical generating capacity on state trust land. So that's over 60% of the total capacity that's on state trust land. Additionally, the board has 2 wind planning leases, 5 utility scale solar planning leases, and 1 battery storage planning lease with NextEra currently. All of these leases combined result in an annual lease payment of over $2 million annually for the school trust. Additionally, there are 3 more planning leases, 1 solar and 2 wind, that are near execution that I hope to finalize within the next few weeks. So needless to say, NextEra continues to be a proven company that can bring these projects to fruition and has been a great partner to the State Land Board. So regarding this specific proposed production lease, the project, again, just to give you an idea where it's located here in the northeast portion of, here's Pueblo County, and it's in the northeast part of Pueblo County.
David, sorry, well, also for curiosity, where is the Thunderwolf? Is it just north of that?
Good question. I have a slide that shows you that.
Oh, okay.
So, yeah, to give you a little bit more context, so here's the project that we're talking about right here. And then down here, you see the Thunderwolf Solar Project in yellow. And then all the other orange parcels you see here are other existing utility scale solar planning leases. In addition to Thunderwolf, we have 2 other utility scale solar production leases, although our portion of that project is pretty small. So you can see here that little yellow spot there, that's 40 acres and one of the other 3 production leases that we have, utility scale production leases. And over here you see 2 parcels, that's 80 acres within a larger solar project that's occurring over there. So we have those 2 production leases in place as well. So here's a close-up view of the project area. The State Land Board entered into a planning lease with NextEra in November of 2017 for Section 16. That's this parcel right here. In 2023, the board acquired 1,600 acres from the Federal Bureau of Land Management through one of several in lieu transactions. That's all of these acres that you see right here. In late 2023, NextEra expressed interest in adding those 1,600 acres into their existing planning lease. So now, currently, the planning lease consists of all 5 parcels totaling 2,240 acres. That's all you see in orange here. So the Highland Solar 1 project, it's essentially phase 1, includes approximately 2,000 acres of private land. So that's this area you see within this yellow line. And 102 acres of state trust land. The 102 acres consists of 97 acres in Section 16, which you see down here cross-hatched. And then an additional 5 acres up here in the northeast portion of Section 6, which is there to provide access into the project. The project will produce up to an estimated total of 300 megawatts of electrical energy capacity with a 100 megawatts of battery storage. The project will produce 19 of those megawatts on state trust land. NextEra has requested to keep the remaining acres that you see here under a solar planning lease because they are working on a phase 2 of Highland Solar, of which a significant portion is planned to be on those state trust land parcels. That's the remaining acres you see here. They'd like to keep under a solar planning lease. So this map is just to give the board a visual of what the solar array will look like within the project area. It's not exact, but sort of an approximation of what the project will look like. So the proposed lease terms will consist of the 102 acres as shown on the previous maps, which will again produce up to 19 megawatts of power capacity on state trust land. To give the board some context, 1 megawatt can provide power for approximately 300 homes. So this 300 megawatt project will power 19,000 homes in total, of which the portion on state trust land can power approximately 5,700 homes. The lease will have up to 24 months to construct the project and a 25-year production term, which is in line with their power purchase agreement with Xcel. If the board approves the production lease, project construction is expected to start in the summer of this year, and the commercial operation date will be in the summer of 2028. So the total revenue that the board will receive from this project is approximately $2.5 million over the course of the 27-year term. That total includes 2 main parts. The first part is a one-time payment of $171,300. which includes an installation fee of $28,500 and then a construction period payment of $142,800. This lease is a bit unique in the sense that staff was able to negotiate a significantly higher construction term payment, which is $700 per acre per year, whereas the construction payment is typically more in the range of $15 to $25 per acre per year. The second part that you see up here of this total is the production payment, which consists, again, starts out at $700 per acre per year, or $71,400 per year, escalating 2% annually, totaling about $2.3 million over the 25-year production life of the lease. Staff will also collect a performance bond of $500,000 that would be held for the life of the lease. This bond is used to ensure performance of the lease and to ensure that the land is restored appropriately upon expiration or termination of the lease. So staff followed all agency procedures regarding lease application review and analysis. Prior to issuing a planning lease, the Renewable Energy Program Manager solicited feedback from the district manager, stewardship trust team, the Conservation Services Manager, and all other program managers. No significant issues or concerns were identified during the internal review. There were some additional conditions or stipulations that we added to the lease, but other than that, everyone was in support of the project in this particular area. Additionally, the State Land Board's agricultural lessee, Thatcher Land and Cattle, who currently leases Section 16, just Section 16, not the others, is also the private landowner of the other acres within the solar project. As part of their negotiated agreement, NextEra is purchasing the land from Thatcher Land and Cattle. The proposed project will follow all local land use and regulations, as well as all federal and state regulations and requirements. There's no exceptions because they're on state trust land. Additionally, for use with all renewable energy leasing decisions, staff developed BMPs, best management practices, for renewable energy projects through consultation with industry experts and other state and federal agencies, including CPW. These BMPs that are in the renewable energy production leases direct the lessee to mitigate potential adverse impacts to state trust land that may occur during and after project development. BMPs also help ensure successful site restoration after initial construction activity and, again, at the expiration of the lease. So other considerations, NextEra has executed a 25-year power purchase agreement with Public Service Company of Colorado, Xcel, and will deliver the power to the Sandstone substation, which will be just south and east of this project. I think it's within a mile of this project. The substation is part of the Power Pathway project and will be built within the same construction timeline of this project, so it's not built yet. NextEra has also obtained their 1041 permit from Pueblo County and have completed their environmental studies as well as their consultations with CPW and the U.S. Fish and Wildlife Service. No issues or concerns were stated by either agency. So benefits from the solar project will be that the associated lease will generate significant long-term and consistent revenue for the school trust. It's the highest and best use of the land, and the ag lessee is participating and benefiting significantly from the project. And it supports the State Land Board's renewable energy goals, as well as Colorado's long-term renewable energy goals. Additionally, this project will increase the total megawatts of generating capacity on state trust land, like I mentioned earlier, from 667 megawatts to 686 megawatts of electrical generating capacity. This will leave the board needing to obtain only another 64 megawatts over the next year to achieve the governor's WIG of having 750 megawatts of renewable energy being produced on state trust lands by the end of June 2027. The board has several key planning leases that I believe will turn into production leases within that time frame to not only meet, but hopefully exceed that goal. Okay, sorry for the segue, but back to the project. So staff recommends that the board approve a solar production lease with Highland Solar One LLC for a solar project located on 102 acres of school trust land in Pueblo County. The lease will include the terms described in this cover sheet. And with that, I'm happy to answer any questions the board may have. And Evan Raimondo with NextEra Energy is also online to help answer any questions that you may have for them. And then I also have the board order up here for your convenience.
Thank you, David. Questions?
David, do you mean that our current solar production leases amount to 687 watts? Is that when things will be in production from those that we've approved?
Sorry, that's actually our wind and solar combined is equal to the 667. And this will add another 19 to that. But that other number is the total of, actually it's wind, utility scale solar, and solar gardens. It's our total megawatts on state trust land.
Good, thank you.
David, could you bring that map up again that showed the layout of all the solar panels? Yeah, and I'm curious why that layout. Why does it touch that little corner of our land and sort of go pyramidal? Is that just the way you design an array, or what's the explanation there?
Well, that's a good question. I don't know if I have a good answer for you. I know that NextEra was certainly trying to include some state trust land in phase one, knowing that we could, obviously be a bigger partner in phase two. And then partially, of course, they needed access up here. And I think part of that was, let's put some of this down here on state trust land, which is why you see just that little piece on our land. That's what I believe occurred. Again, Evan can probably answer that more detailed if you want to hear from him.
My other question is, a couple more questions. Yesterday, one of the commissioners in the public or the roundtable expressed a worry about renewables taking up ag land. And I'm curious if we've ever done sort of a back of the napkin projection of, say we developed all the solar power the state could use on state land. I assume it's still a very small fraction of our 3 million acres. And I wonder if that should be done, not a huge study, but so we could reassure our ranchers, our ag guys that, there isn't a big danger.
Yeah, that's I was just going to say, we did do a back of the napkin study about that.
Okay.
And I don't have the numbers in front of me, but it is a very small portion. Chris may know that off the top of his head.
Yeah, I can answer that, Commissioner. Christopher Smith, Assistant Director for Energy Innovation. When we did this, it was about 4 or 5 years ago, and at that point in time, the number was about 50,000 acres. But I believe there was an article in the Colorado Sun in the last 2 weeks about a recent study, and that I think that indicated like 70 to 80,000 acres. I can look up that article and forward it around to the commissioners.
Okay, and then I'm also wondering if NextEra, obviously these guys out in rural areas are worried about their towns and jobs and money. I wonder if NextEra can make an emphasis on hiring, people out in rural towns to do any maintenance. And some of it obviously takes real training, but there's probably some stuff that, ranching kids would be really good at mowing these arrays. Just put an emphasis, and maybe down the road, there's even, they have some tech centers out there training people to assure the rural people living in rural areas that there's actually a boon to some of this as well.
Oh, Mark, I said Evan Raimondo, but it looks like Mark's here instead.
Yeah, okay. I jumped on. I was actually down here in Pueblo for a hearing this morning, so Evan was covering for me, but back here now. So, Mark, I appreciate the question. We do, since we have a couple sites down here, we have what's called an O&M facility that's located here in Pueblo. And the numbers I had them ready for this morning for the hearing, so good timing. But we have 8 folks that work at the local O&M facility here. 5 of them were local to Pueblo itself, and 2 of them were Colorado resident. The 2 of the other ones were Colorado residents. So it obviously it definitely benefits us to hire local here. And then the stat on the other 2 sites that we have operational down there, Mark, is we had between 85 and 90% Colorado. It wasn't Pueblo local, but it was Colorado workforce during the peak construction for those 2 sites that we have that are operational now. So it definitely benefits us to use them too. We're not paying for per diem,
Yeah.
is financially, right? And it's and understand, especially down in Pueblo, that how important jobs are down here. So absolutely, we're pressing that with the folks that we work with as well.
And are you guys doing any specific training in any community colleges or 4-year colleges to to add to the local employment?
The workforce. Yes, we do. We do a lot of training. I couldn't tell you what colleges. I know we work with some of the colleges. We also have a training facility for our techs it's a dedicated there's a wind facility in Iowa that we take all our techs to if they get accepted into the program, and it's like an apprenticeship program that will move them all through. And the solar side has the same thing as well. So we do help out in the colleges and the universities. I'm not sure completely to what capacity, but we have our own, because of the size of the company, we have our own like apprenticeship program that we sponsor folks through and carry them through to train them and get them the training that they need.
Okay, thank you.
Yes, sir.
Yeah, I'm curious, and Chris or whomever, with grazing leases, we have this complicated formula that gets recalculated every few years, and so, and with other leases, you have probably competitive market pressures. What are the criteria that go into setting the production lease rate, or what's fair market value for a solar installation?
Yeah, that's a great question. So as you can imagine, this industry has changed a lot in the last 10 years. And so that was a little bit of a moving target, and it's gone up in the last few years. What David has negotiated here is a good market rate for utility scale solar. I can tell you when we signed Thunderwolf 5 years ago, we're closer to $400 an acre on that with NextEra. And so it's gone up. The way that we, sort of monitor that market is we, not only are we involved in the industry with several different solar developers in understanding that, but we also communicate with our neighboring states. And we have a most favored nations clause in our leases that say that in the same project, if the developer is paying somebody else more, then we will get a rate to match that.
And
So, yeah,
Commissioner Pribble, I'll add to that, just saying that in this particular situation, two key things. One is there's obviously a private landowner that has a lot of acres involved. So, we leverage off of that to some degree. But in this case, NextEra came to us with an amount that was, because of our small amount of acres in the project, is greater than what the private landowner would have gotten in this situation, even though it's a disposal or an acquisition as opposed to a deal like we have. But and yeah, in this case, that's very helpful. And plus the fact that, again, we have a most favored nations clause in our leases.
I would note, sort of anecdotally, Nick sent me an article 2 days ago that Utah had just signed a 1 gigawatt solar lease. And so this morning before our board meeting, I emailed with the director of Utah's SITLA, their land board, to see if we could get a copy of that lease.
Great. I have a question, David, or maybe it's for Chris. Yesterday during our workshop, I think it was yesterday, we touched on the idea of using one of the next solar leases or several of them to test the agrivoltaic situation. Is this one, have we had any of those conversations? Are we looking to do that here?
Yeah,
David. Yeah, I was just gonna say, good question. So this was actually, when we had some folks meet with the board at a workshop several years ago, including Alan Knapp with CSU. This was actually one of the sites that was sort of targeted for a potential collaboration there. And so I think some folks at Nextera have changed as far as responsibilities, but you all probably remember Nathan Smith. I'm sorry, Nathan Kaiser. We started our conversations with him, and Nextera seemed interested in trying to work something out there. There's a lot of different, Alan has a very large wish list, and he understands that maybe, out of the 12 things that he wants, maybe we can accommodate or work through 2 or 3 of those things that are really important. So it's been a while since we've had those conversations, and I think James and Chris are picking up that conversation with Alan and Nextera to see what we can do. But it was never planned for any of these parcels over here. It was sort of contemplated to be in this area over here. And I'm not sure how much, Mark, you're aware of all those conversations about that collaboration, and when I say Mark, I mean Mark Goebel. So I don't know if you have any comments on that, Mark, but Commissioner, I just wanted to mention this was the site that we were talking about. And of course, just to clarify, as long as it's a planning lease, we can't really do anything or move anything forward until it becomes a production lease. But the key thing is to have these conversations earlier, so that we can, it can be part of the planning process, which we've started. But again, it needs to be picked up again.
Yeah, we'll definitely, we are in a conversation with Alan Knapp currently. We're going up to see one of their facilities next month in Larimer County or Weld County too. And we'll pick up conversations with Nextera and other developers as well.
Great. Well, it seems like good timing with now the plan lease is getting approved, and there could be other phases, et cetera. Terrific. And I see a hand. Is that a new hand, old hand? I can't read from here.
It's Mark.
It's an old hand. Chris, when you mentioned those 50,000 acres, that back of the napkin, is that on state lands or is that the entire state? For developing?
Yeah, that was the entire state, but I actually pulled up the Colorado Sun article, and I can quote from there. An analysis was done for the Colorado Energy Office, estimated to meet the need of the state's 2050 clean energy goal. Colorado will need 12,000 megawatts of large-scale solar, which will need 60,000 to 80,000 acres. So that's a direct.
Okay, but that's total.
That's total, yeah.
So I assume, again, it might be interesting to find out, without doing a very expensive study, what the projection would be on state lands, because 50,000 acres is of if it was into state lands, that's about 1% or something, 1.5%. And I assume it would be a fraction of that. It would probably be 1/4 of 1% or something. I have no idea, but it would be I would think it would be a very small amount, even if you fulfilled those 2050 goals.
Yeah. I agree.
Mark.
Yeah, sorry, David, go ahead.
That's okay. Just in addition to that, Mark, I just wanted to say, we did do again, back of the napkin, sort of specific to state trust land. And what we did was project, let's say all of our existing solar utility scale planning leases went into production. We kind of had that number, right? Because that's the worst case. I say worst case scenario, worst or best case scenario, depending on how you look at it. But that would be all of those acres. And I can pull that up. I think it's around 20,000 acres. And again, that's okay if they all go forward. And clearly, it's going to be a percentage of those, not necessarily all of them.
So I think that's roughly 1/2 of state lands. And I guess I don't know much about agrivoltaics, but I assume it's elevating the panel so animals can graze underneath. Is that essentially what an agrivoltaic is?
Yeah, agrivoltaic is maybe an umbrella term for other things. And something like cattle voltaics could fall under agrivoltaics. Agrivoltaics has mostly been used for farming, and in a lot of ways it's been small scale, but there are some utility scale agrivoltaic projects now, a handful of them throughout the United States and Canada. The way we're looking at it is cattle voltaics. And so far that has included having to raise panels, which has what we found is pretty cost prohibitive. And that's what kind of stalled out the discussions on agrivoltaics on this site. But going forward, I think we're rethinking it and seeing if we can use the ability to stop the tracker to tabletop the panels, coinciding with regenerative grazing, to sort of use what's there today and let cattle out there to see if it, see if they can mix and if they do any damage and quantify that.
Correct. And finally, David, I just want to commend you on all this work. I'm a big renewable fan, and it's great to see it happening.
Appreciate that, Mark. Or Commissioner Harvey. I also wanted to say that Chris mentioned that it sort of killed the project here, the idea that how much it would cost to raise panels. But it was just that portion of the project. I mean, like I said, Alan's got a whole list of things that he'd like to study, the effects of solar panels, in an area, whether the panels are closer or further apart, those sorts of things. And then, of course, include different forms of agrivoltaics, whether that's, installing pollinators or other things, or even sheep grazing. But the big question we want to get answered is, can you put cattle in a standard solar array situation? And I think one party says no, some others say, well, we don't know. I mean, the truth is we don't know, because I don't know that it's been truly tested yet, but that's sort of some of the things we want to find out.
Yeah. And David, if I can add, this is Mark Goebel again. And Commissioner Harvey, I apologize. I only see your name up there, and I saw you asking a question, and I haven't been on all day, so I apologize for not addressing you accordingly there, sir.
No problem.
For the other two things that we kind of run into is the insurance challenges. So all of our sites are insured, and so we're having difficulty getting some of these folks at insure our projects to really sign off on the agrivoltaics, because they don't want anybody within the fence line for whether it's getting shocked or anything like that. So just the safety hazard. So it's difficult from an insurance perspective to get folks comfortable on these large scale sites. And then the other ones is that we have pretty hefty fines and obligations per our power purchase agreements on the utility side that says we have to provide X amount of megawatts per day, per hour, and it's got to be ready. And so it's difficult getting customers comfortable with the possibility of, if we don't raise panels, that one of these animals rubs up against a panel or starts chewing through wires, and then you have a whole portion of the array go down. And so it's definitely something us as NextEra have looked into. There's just some challenges on the utility scale and certain obligations that we have to fulfill, and trying to get all the parties comfortable with it.
And just one other thing I'd like to add regarding agrivoltaics, just to let the board know sort of how our communication works. But I would say anytime we start to issue or think about issuing a planning lease, agrivoltaics is brought up as something that the board's very interested in, and it sort of makes a difference in our projects that our developers are considering that. So we bring it up constantly. So even if it's on the scale of just allowing sheep into a site, or things like that. So like we have a couple planning leases in the northwest part of the state where there is an actual fair amount of sheep grazing. And so we hope to integrate some agrivoltaics in regards to sheep grazing into those projects if they come to fruition.
I think this might be a good way for us also to see whether we could partner with them. We talked about taking some risk on the agrivoltaics if we could partner with someone. And it is surprising that NextEra, as large as you are, that you haven't had any even experimental tries on agrivoltaics. Is that something you'd be interested in exploring with us?
Yeah, I think so. And we have tried it. We just haven't been successful in it yet. So we've tried it in other states. We have Florida Power and Light as well, our utility in the state of Florida that's rather large. And we've tried it. We just haven't found success. And I mean, it would behoove us to figure out a solution, especially if it was with sheep, because we have to mow and make sure that nothing's blocking the panels. And so if there's a cost-effective means to get sheep out there or some type of grazing out there that of course doesn't damage the panels, it would greatly benefit us as well. So it's definitely something that we'd be very interested in continuing the conversation on and trying to figure out.
Yeah, I would think, you know, with cattle, they're 1,000-pound animals that love to scratch their backs on any fixed object. So I would think it'd be difficult to find a good solution, but maybe there is one.
Sorry, that sparked one more comment I'd like to make. I can't remember if I spoke about this to the board, but I know internally at our directors meetings, I mentioned this, but there was a company that reached out to us that I think they started out in California, but they now have a presence here, and their company goal, their whole motive is to basically manage sheep grazing within existing solar facilities. And so, of course, they work on an arrangement with the developer to be paid for that. And some of the benefit is taking care of the grasses, like Mark said. But then it feeds the sheep, and then they, utilize the sheep, of course, for selling or whatever.
Yeah.
But they have a presence here, and I talked with them originally, and I got to remember if I've introduced them to James yet. I may not have. If not, I'll do that. But the idea is maybe we can utilize them or work with them on some of our existing solar gardens. Usually those are too small to really be cost effective, but potentially maybe talking with Nextera about maybe integrating something here at the Thunderwolf site.
Or keep all your weed eating goats around the solar arrays and just bring them out when you need to take weeds out.
Yeah.
Well, thank you, David, for this presentation, and Mark for your contributions. Shall we see if there's any, being no more questions, shall we see if there's any more public comment or any public comment?
You bet. If you're listening along online and wanted to comment on this item, please raise your hand. Bring you forward to hear from you. No hands raised, Commissioner.
Right. So, commissioners, how about we have a motion for this matter?
I'll make a motion.
Okay.
Oh, go ahead, Jim. No, go ahead, Mr. Go ahead, Commissioner Pribble.
Please, you do it.
Okay. My motion is that the trust approve a solar production lease with Highland Solar LLC for a solar project located on 102 acres of trust land in Pueblo County. The lease will include the terms described in the cover sheet and exhibits.
Thank you, Commissioner Harvey. May I have a second?
Second.
All right. Is there any further discussion, any comments on the merits of this opportunity?
I think I'll speak for, I believe my fellow commissioners were very excited to see this come online.
Yes.
Been a little
Here,
bit,
here.
a little bit of time in the making. Good work to all involved.
Yes, I like that it's seems like our participation in this is a gateway to perhaps another phase. And again, extending a very valuable relationship with Nextera. The economics are sound, and it certainly gets us closer to Colorado goals, as well as generating substantial revenue for the school trust. So let's have a vote. Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Yes.
And the chair votes yes, so motion carries 5-0. Thank you for your hard work. And
Can I make one quick comment? I just want to commend David for bringing us what I think is the most lucrative lease on newly acquired in Lou land for us.
Nice.
So,
yes,
That's great.
opportunistic.
Yeah. Thank you.
Thank you very much.
Thanks, Mark.
Yes.
Absolutely. Thank you all.
All right, Mr. Bissett?
No.
Kate.
Yeah,
Oh, helium, right. Sorry about that.
All right, commissioners, good afternoon. Katie Stitt, Oil and Gas Leasing Manager. Today I'm bringing forward the oil, gas, and helium lease auctions for April 2026 standard list for your consideration. This is a final action item today, requesting the board's approval. It's being brought to the board because this falls outside the scope of decision-making authority that the board granted the staff by the oil and gas development policy. This is relating to the oil and gas leasing program. We received 36 nominations from industry for this auction, mostly for tracks in eastern Weld County. This is where operators are still working on defining the boundaries of the Denver-Julesburg or the DJ Basin, which is the most productive basin in Colorado. Horizontal drilling technologies are just starting to move into this area of Weld County. And staff is recommending moving forward with the leasing on 35 of the nominations we received. We have one nomination that is in this area, but the land is also in part of the stewardship trust. The stewardship trust requires us to notify the nominators and additional parties when there's a new use going on the property. Oil and gas is not a new use on that property, but we want to make sure that everybody is aware of the potential releasing of this for oil and gas. So that parcel is not on this list that we're recommending for the board approval today. So the April auction list represents about 13,000 acres. The tracts that are nominated for approval are the red dots on the map, and they are located in Jackson, Moffett, Morgan, and Weld counties, which are outlined in blue on the map. As I mentioned, most of the nominations were in eastern Weld County, also very western Morgan County. It's pretty much all like a big cluster of nominations right in that area. And this is where the horizontal development is moving eastward towards in this area. And then we have some nominations in Moffett County and one nomination in Jackson County, which are more exploratory in nature. There's projects going on in those areas, but they haven't moved into full-scale development at this point. So we consider these more prospective nominations. These tracts will all be offered at the board standard 20% royalty rate. The auction does start on Thursday, April 9th. It'll end the following Thursday, the 16th, on Efficient Markets. That's EnergyNet's new name. So it's Efficient Markets, but it's still the same platform that we've been using. We reviewed all of these tracts per our oil and gas development policy, and all the stipulations that we're recommending to address comments from both staff and CPW are on Exhibit 2 to your cover sheet. I did want to bring up that we have one new set of stipulations involving the greater prairie chicken. We've had a lot of discussion about the lesser prairie chicken, but this is a relatively new comment and feedback from CPW on the greater prairie chicken. It's related to their LEC and priority habitat mapping that they've done. So this stipulation in particular requires a LEC survey to be done within 2 weeks of when they are planning initial site development. That makes this a very timely stipulation, because if they find a LEC there, then that means we're going to be stopping the movement forward of that project at the time to discover what, if anything, needs to happen, including additional stipulations like a no surface occupancy for that. So it's very much time specific. Our stipulations allow us to impose additional requirements up to the time of drilling. So this is a pretty big example of how our lease is maybe a little bit more aggressive than the standard oil and gas. So with that, staff is recommending that the board approve the standard list of 35 tracts covering 13,103.3 acres, 0.03 acres, including the stipulations on Exhibit 2 to the cover sheet. And I would be happy to take any questions. And I do have a copy of the board order that was in your packet for your convenience.
Questions, commissioners?
Katie, can you remind us why this is outside of the normal, why this needs to be board approved? Is it because of the stewardship land, or is it because of the helium?
We as staff do not have the authority under our policy to offer any lease. We can bring recommendations to the board, but ultimately the board decides what lands you will and will not lease for oil and gas development.
Okay, I thought this was a special case or something for some reason. Okay.
No, you get to see me about 3 times a year, assuming we have nominations for oil and gas leasing.
Yeah.
I have some comments, but I'll save them for the commissioner discussion.
Chair,
Yes.
I've got a question or two. The DPW Regional Northeast Regional Manager submitted an 11-page comments doc with concerns about a variety of species. So by virtue of including these or this document, are we promising, and is the leasee compelled to abide by all of the various restrictions that are recommended here by CPW?
I'm going to say essentially yes. So our process when we obtain the comments from CPW or from our internal staff, because we have quite a set of experts on our own staff, we also reach out to local governments to provide comment. I believe there's a letter from Jackson County in the packet as well. We also reach out to Denver Water. When we obtain all those comments, we sit down and we have a meeting amongst our internal staff, and we develop stipulations that we put on the lease to require the lessee, whoever that may be, because we don't know who that is right now, that they have to work with us in establishing the concerns that CPW brings up. So for example, on the LEC, on the Greater Prairie Chicken LEC habitat, CPW wants a survey done. We require that. If they don't find any of the applicable bird habitat or nesting activity there, then we reach out to CPW to find out what their recommendation is next. So our stipulations have like the first initial step. But if you look at Exhibit 2, which lists all of the stipulations in their exact verbiage, most of the stipulations all require spacing recommendations. For example, 1 surface location per square mile on some of these parcels. So it looks at the area more than just what's on our property, but in general. There's noise regulations, so they can't have equipment out there making louder noises than at certain designated noise levels. When we get to the point where they're moving forward into potentially permitting, those stipulations are placed on their permit requirements by our surface technician. So the stipulations are all designed to address CPW specific concerns, but we do it in phases to make sure that the person who's bidding on this knows what to expect when they buy the lease. Because some of these survey requirements, some of the technologies they may have to use to meet those requirements are expensive. So we want them to be upfront and knowing that you're agreeing to this when you take a lease with us. But 2, CPW may revise their recommendations by the time development happens, and we want to make sure that we're getting the most current recommendations for each species at the time drilling occurs. So there's some room in our stipulations to allow for more restrictive. I can't think of a single instance where our group, which includes our stewardship team, has ever recommended less than what we put on the lease.
And so from what I take from that, we can summarize or generalize that all these proposed restrictions suggested by Shannon Schaller here are embedded in the lease's or the lease's requirements. What is our capacity then to enforce that or to monitor and enforce that?
So we monitor through a variety of mechanisms. First, when they are ready to drill, they have to consult with our office first. So that triggers a set of review internally. So Steve Fries, who's our surface technician, will go out and meet with the lessee on site where they're wanting to do their work. CPW gets brought into that conversation that time. We reconsult the Colorado Natural Heritage Program database to ensure that they haven't added additional requirements. The lessee and also our office looks at the Office of State Archaeology. They have an official name, and I'm sorry, I'm blanking right now. So we make sure that there's not been a newly reported artifact or archaeological site. We do all of this again when the sighting occurs so that we're looking at current information. At that point, there's discussions about how this is going to work for the location. Some of that gets put into the permit in addition to the stipulations. The regulatory rules in place at that time also play a role here. Our lease requires compliance with the law in effect at the time. So there's a bunch of things that happen when drilling occurs. The reason, and this is my lawyer training, I'm not telling you that every word of that letter makes it into the STIP, is because let's say the timing changes, let's say the species breeding season extends. We're going to include the larger time frame. We're not just going to limit to what they say in the letter 4.5 years. That's my hesitation in saying yes, flat to your answer.
Thank you for a very comprehensive. Yes, it's well done. Katie.
Katie, oh, sorry.
Oh, please go, Commissioner Harvey.
Katie, there was a pretty extensive article in Rolling Stone magazine, of all magazines, recently about the toxicity of injected wastewater, that oil and gas basically pumps 1 trillion gallons a year back into the ground. And that the safety of that water and the monitoring is much less stringent than we'd like to believe. And I assume some of the, wastewater that would be reinjected in that area is pretty near some of those aquifers. So I would just hope that, first of all, that staff would dig up that article, get a subscription to Rolling Stone magazine. And it was quite a good article. And but there's just so much water being re-injected back into the ground that hits these, apparently hits some of these water tables and aquifers, and especially that part of Colorado where, the aquifers are so important. So I would hope staff would carefully explore that.
It is all part of things that we monitor. So that's all I can really say without having some specific examples of having not read the article. But yes, I will go look for it.
Great.
All right, any further questions? Let's see if the public has something to say, Nick.
Yeah, folks listening along online, if you'd like to comment on this item, raise your hand. No hands are raised.
Right, may we have a motion then, we approve this oil and gas auction list?
I will move that we approve the, the auction received, yes, I'm trying to find the date of it. April 2026 standard track list as presented at our board meeting.
Thank you, Commissioner Scanlon. May I have a second?
Second.
From Commissioner Pribble. Other commissioners have any comments or discussion points they want to share? I have one, which two actually. One is I'm reminded each and every time I look at these of how thorough the process is and the amount of detail that our colleagues at CPW go through. And I know, whether it's CNAP or CNHP, TNC, everybody, it really takes a village to come up with the document that we have for each and every one of these leases, should they be successful. So again, I'm reminded of how much effort it is and how carefully you all undertake this, knowing how important. And the other thing that strikes me is kind of apropos of our conversation yesterday about greenhouse gas emissions, and this isn't meant to be an escape clause exactly, but here a nomination is back in because our surface won't be disturbed, but next door they're doing the drilling, and we have control over our lands subject to our mandates, but there's a lot of other land out there and a lot of other operators. And the consolation I have in knowing that we are still leasing oil and gas is that we are absolutely doing it better than anyone else, but a lot of people are out there doing it. So just something to keep in mind. All right, may we have a vote? Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Commissioner Scanlon?
Aye.
And the chair votes yes. Auction list order is approved 5-0.
And I appreciate the inclusion of the greater prairie chicken, Because I think including species, learning more, and CPW is awesome with their review of wildlife and species management. I think that's terrific. So I want to echo Commissioner Probst' comments.
They have a great team over there.
They do. They're very thorough.
They seem like they really care.
Yes, they take their time.
Thank you for a
Katie.
very thorough presentation.
Now we get in.
Thank you for your good work getting our packets this month.
Absolutely, my pleasure. Yeah, hello, Commissioners. Andy Bissett, Transactions and Record Services Manager. We have a number of policies to review with the board this calendar year as part of the board's regular 3-year policy review cycle. Many of those being presented in the first half of this year are from our administrative series or the 200 series. You heard one earlier today, and I'm here to present another, the Legal Action Delegation Policy 200-003. There are no slides for this item. The policy's objective is to delegate authority to the director in consultation with the Attorney General's office to initiate and resolve legal actions to protect state justice. In review of this policy, staff consulted with the Attorney General's office on recommended modifications. The proposed modifications found in your board packet include, under criteria, the addition of pre-lawsuit settlements as a legal action to which the policy more clearly applies. Here, lease default is the most common pre-suit settlement where staff discovers a lease violation, no lawsuit is filed, but the agency and the counterparty nevertheless enter into a settlement agreement so that the board releases claims in exchange for some sort of performance. Under practices, the addition of clarifying language as to the existing threshold amounts to which the policy is limited in its application. Overall, staff and the Attorney General's office feel the policy is effective in supporting the business activities of the agency, and both are available if there are any questions. Staff recommends the board adopt the proposed modifications to the Legal Action Delegation Policy 200-003.
Any questions, Commissioners?
No, they seem pretty modest.
Yes.
I was gonna ask, why did this come before the board? I mean, is it so onerous that they come to the board or?
Legal actions?
Right.
Right, so the policy essentially is delegating a lot of the non-significant actions. The authority under the $200,000 threshold to just initiate and resolve those kind of on their own without really seeking individual board action.
All right, shall we check for public comment?
If you're listening along online and wanted to comment on this ET matter, please raise your hand and we'll bring you forward. There are no hands raised.
Okay, thank you. Commissioners, may we have a motion?
If you wish, I move that the board approve the proposed modifications to Legal Action Delegation Policy 200-003. Also found on page 141 of the board packet.
Thank you, Commissioner. You have a second?
Second.
Thank you. Any further discussion? I like the fact that it's been working well, and I like the fact that responsibility is delegated to staff so that we don't have to see all of it. Yeah. All right, let's have a vote. Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath?
Aye.
Mr. Scanlon?
Aye.
Commissioner Probe? Votes yes. Motion carries 5-0. Right. Now, Andy,
Yes.
another at bat here for board leasing agenda.
All right, yes, for the record, Andy Bissett, for the Transactions and Record Services team, here to present the March 2026 board leasing agenda for your review. This month, we have 3 competitive bids, 2 agriculture and 1 recreation. Again, those are found in your board packet. Happy to take any questions on those, but staff does recommend approval of the March board leasing agenda.
Okay, go ahead.
So is this Maggie Hannah's family?
Yes.
And is this adjacent to their ranch? I know she's come to us earlier on several occasions to talk with us about issues that have been of concern. And I just wondered if this is adjacent to their existing ranch.
Their deeded land. I'm not particularly sure about.
Elliot Hoy, Assistant Director. It's nearby. I think it touches part of the family's ranch. It's a property that sort of stretches up and around, and it's got some of the solar nearby. So some of those things that she's been concerned about in the past. But yeah, she
has had very thoughtful questions
yeah,
for us.
that's a great partner.
I think they've been very instructive.
Yep, absolutely.
Great.
Won the award last year.
Rachel Turner, texting from abroad. Yes, it's adjacent to the Hannah land.
Thank you. Andy, I had a question on that same matter. To understand, I didn't really quite understand the language here, so the existing lessee is Hannah Ranches, but they did not meet or exceed the bid and didn't meet the requirements. But then, if I'm reading into this, then they were awarded it after an evaluation straight across of the other competitive bids, correct?
That's right, that's right. After not meeting the requirements of the statute, it goes to
An open
competitive
market
situation.
Right.
And so both were evaluated.
Okay, and 1 and 2, is 1 the Hannah Ranches, is that?
1, yes, is the recommended awarding party, and that is, yes, Hannah Ranches.
Okay. All right, thank you.
Sure.
Is there any public comment on this matter?
Listening along online and you wanted to raise a comment about this issue, please raise your hand. No hands raised, Commissioner.
All right, I have a motion for approval of the board leasing agenda.
Now, Chair, I move the board adopt the board leasing agenda for March 2026 as contained in our board order in the packets for today.
Thanks.
Second.
Second from Commissioner Scanlon. Is there any discussion? All right, let's have a vote. Commissioner Harvey?
Aye.
Commissioner Pribble?
Aye.
Commissioner Heath? Aye. Commissioner Scanlon? Aye. Chair votes yes, motion carries 5-0. Thank you, Andy. And unless another commissioner has any changes or comments about the board meeting summary from February 12th, I would move these be accepted by acclamation. Right, so considered approved by acclamation. Now, the last thing is, and I don't know if anybody had submitted anything, does anybody have anything top of mind under commissioner items?
I'll just say that I had the opportunity to listen to the Zoom on the working group, and I want to commend our staff and the working group for how much they've put into this. It's clear that people are really taking this very seriously, and I think our staff particularly has been really commendable for all the work you put into this and the education that you're doing. Certainly some themes that come through here pretty clearly, and communications really at the top in terms of people understanding what we do, and why we do it, and also the environment in which we function in terms of what restrictions are. So I think our communication function is just not just press releases, but we have to do a much better job of letting people know what we do.
Yeah, engagement, one-on-one too.
And some good ideas have come forth. That I've found that I'm sure will be reported out. But one was using volunteers on stewardship land, much like they do with the natural areas program, and some other suggestions that I think really had merit. So just it's interesting to listen.
I agree with you. So a +1 on commendation for staff. It's been a huge effort. I think it's been as or more valuable perhaps than we all imagined, just for the reasons you noted. But it is a lot of effort in addition to all the other things we're doing. So thank you. And thank you for sharing your insights. I meant to sit in on that virtual session, but I got the day wrong, so I missed it. But I guess it's recorded, right? Okay.
And for what it's worth, the next meeting is also going to be virtual for that group. So we'll make sure that you're patched in, you know how to access that meeting.
Great. All right. Well, thank you for a productive couple of days. Oh, yes, Commissioner Harvey?
Well, I was just going to add to just the excellent work of the staff does in general. And I thought the comment from, I can't remember her name, from the STAR community today, who came back on and, you know, even though we didn't make decisions in their favor or exactly what they wanted, how she was, you know, pleased with the discussion and the openness of the board. And I think that was just a great comment.
Thank you. I agree. Some of us talked about that here as well. It was sort of an acknowledgement of our active policy of engaging and listening to the public. We learn a lot, and so do they.
Yeah.
Thank you. All right. It's a wrap. Thank you, everybody.
Thank you.
Thank you.
Thanks for hanging on, Mark.
Yeah.
Yes.
Thanks.
I think I'd like to make a note, Madam Chair, that for the political historian buffs in the room, Commissioner Harvey is wearing the trademark black and red plaid shirt worn by former Governor and Senator Lamar Alexander when he ran for Republican nomination.
I'm actually in New Hampshire.
And then secondly, I would wager the guess, although it's a totally unscientific one, that Mr. Harvey is one of the few, at least publicly acknowledged, subscribers to the Rolling Stone magazine who's ever served on the Colorado State Manual.
Actually, I don't subscribe. I just saw the article and they allowed it to read it beyond the paywall.
Oh,
I'm
nice.
always about 20 years behind modern culture, so.
Both sides
Thanks for passing it along, though. I would have missed it.
Proof what an eclectic contribution Mr. Harvey makes.
Thanks a lot for
Thank you.
the whole time.
Thank you.
Good job.